Yes, Mr. Modi.
Marvelous manner. My lord, this is the appeal against the order passed in the Development number 516 of 2019. Now, my lord, I will take the lordship without wasting the time. I shall take the lordship to the page number 29. The impugn order in the writ petition has been quoted here, my lord.
May I please, my lord? My lord, I appearing on behalf of M. Kato, my lord. My lord, matter may be pass over for a while. Cannot continue on it away. For some time. Yes, my lord. Okay. Okay, Mr. Modi, just for a few minutes.
May I, your lordship? Lordship, your lordship, I have a prayer, your lordship, for amending the cause title, your lordship, because due to oversight on my part, respondent number 4 and 5, who were the respondents in the writ petitions, lordship. I'm praying for filing an application for amendment of the cause title, your lordship. I may be allowed to amend the cause title by filing an applications.
Oh, for that you don't need a leave of the court.
Lordship.
You can just get it, bring, you can always file it. We'll just say we adjourn it. At your
Lordship.
prayer. Had Ms. N. Anjul and counsel for the petitioner, as well as Mr. S.K. Deoril and counsel for respondent number 2, and Mr. S. Tapil Leonard, senior government appearing for the state respondents. Next, on the prayer made by Leonard counsel for the appellant, the matter stands adjourned today. Just after.
After.
Next week, my lord, there is an urgency, my lord.
No, I don't know. She will tell us
After a week, your lordship.
after a week.
Obliged.
May it please, your lordships. Lordship, in this matter, LCR has already been received. There are 2 accused in this matter, your lordship.
Is the service report available for the
A legal aid counsel was appointed.
appointed? Okay.
Ginny as a legal aid counsel to represent respondent number 3.
Well, time for the appellant here. And I'm representing the accused appellant, Achung Bagang, and here 2 on the last occasion, the LCR was called. Now, paper book Needs to be prepared now.
Declare.
Lordship, I'm appearing on behalf of my senior counsel, Mr. Yu Deka. He is on a leave, so the matter may be fixed after a week. His name is also listed in the list of absent.
Mr. Tapil. Yeah. Are you seriously objecting to this condition of delay?
I have no.
Okay. Your name?
My name is Tadar Bai. Tadar Bai.
Please write it. Counsel for the applicant, as well as Mr. S. Tapil and senior government advocate appearing for the for the respondents. Applicants, yes. Agreed by the dismissal of the writ petition. The connected writ appeal has been filed by the applicant. And this interlocutory application has been filed to condone the delay of 207 days beyond the period of limitation in filing the connected appeal. Next, the learned senior government advocate has objected to this interlocutory application on the ground that the delay has not been properly explained. Next, we find that the counsel to the petitioner has been blamed for the delay in filing of this the connected appeal. Such consideration, the application stands. The court is of the opinion that the said explanation is good and sufficient reasons for explaining the delay. Accordingly, the delay in filing the delay of 207 days beyond the period of limitation in filing of the connected appeal is condoned. Next, registry shall register the connected.
Sir, number is correct.
Oh, sir. So, okay, according to this, the connected appeal will be listed on Monday. Give it Monday.
Monday.
Yeah. Monday. For admission.
Admission.
May I please, Lordship? Lordship, the affluent herein, that is the nearest Northeastern Regional Institute of Science and Technology. They're challenging impugning the order and judgment passed by the learned single bench on dated 28/11/2017 in writ petition number 326/2015. The affluent herein, Lordship, challenging the order dated 28/11/2017, passed in writ petition number 326/2015, whereby the learned single bench directed the respondent appellant herein to fix the fee of the petitioner at the same scale of LDC as recommended by Sixth Pay Commission. The operative person may take you to last page 129 also. Para 9. May I read also. In view of the above conclusion drawn, the writ petitioner is allowed and the respondents are directed to fix the fee of the petitioner at the same scale of LDC as recommended by the Sixth Pay Commission. Lordship, here the Sixth Pay Commission, on the basis of the Sixth Pay Commission, the basic pay salary of the respondent herein were fixed at the rate of 1800 per daily wages also, which she entitled. The fact of the case is, Lordship, by the order dated 24/11/1995,
the respondent was engaged as a contingent on contingent basis at a fixed consolidated wages of 930 rupees per month for the period of initially for the period of 89 days. However, her period was extended from time to time. Now, in this case, Lordship, the respondent has committed two mistakes. The first mistake, after appointment of the respondent, she was placed as a Hindi typist.
Just a moment before you proceed. You see, in paragraph 1.3 at page 5, you see that the appellant has made a mistake. The Board of Management and order dated so there was a mistake by the authorities due to wrong interpretation of the OM.
Yes, Lord.
This is what you claim.
Yes.
Now, who has arrived at a conclusion that this was a mistake? The Board of Management committed a mistake. Who has said that? Which authority has arrived at a finding that the Board of Management had made a mistake in interpreting the OM dated 10/9/1993?
Yes. Lord.
Because you see, come to page 14, this 1.3 is a matter of record.
That's page number 13.
14 is your affidavit.
Yes, Lord.
Paragraph 1.3 is a matter of record.
And after through examination,
But it's the concept. One clarification. She was given 1/30th of LDC.
that's it.
Initially, she was given 1/30th of the pay of LDC scale,
Yes.
right?
Right.
So you have declared that you have held that post to be equivalent to LDC at
Yes.
that point of time.
Yes.
Now, when you converted her, when you upgraded her, why did you give her 1,800 grade pay and not 1,900? Because you don't have a post of Hindi typist.
Yes.
So why 1,800 and not 1,900? You have already held that it to be same with that of LDC. Why? That much equivalent.
It was our fault on the basis of the lordship.
Which is your fault?
Me-
That 130
yes,
of LDC.
Yes,
That was your fault.
yes. There was a office memorandum saying the lordship, the contingent employee
130th.
who has completed 240 days
Hmm.
in continuous service
Hmm.
as on 1993,
Page.
lordship, page 22A and 23. This is the resolution, lordship, adopted by the Board of Management. Nearest and tribe copy is 22A. In item number 10, to consider the matter of casual workers.
Hmm.
A.
Okay, you mean to say that here it should have been Group D,
Yes,
but you considered as LDC.
LDC, yes. It was our fault. It was immediately regretted by the authority, and it was also communicated to the respondent.
But that was to upgrade here. So 1,800 would take a vacation.
She has been conferred only temporary status, your lordship. So she entitled as per the recommendation of the approval made by the Board of Management. But on very next phase, in phase number 29, lordship, the office memorandum, as per the recommendation of Sixth Pay Commission, is also there.
Contingent employee cannot be against any possibility in the book. What जो भी है गवर्नमेंट ऑफ इंडिया का डिसीजन था कि उसको ग्रुप बी का तो 130 पे करो। अगर कन्वर्ट किया है तो उसको जो 130 दिया अब हम लोगों ने उसको एलडीसी पकड़ के दिया वो गलती दिया तो किया हमने उसको ठीक है ना बट बियॉन्ड ग्रुप से तब उसको ग्रुप से Who is appearing for the petitioner?
You are appearing.
Mr. Lambu?
Yes, ma'am. Yes, what is your stand? How can you establish this things?
Yes, my lord, reported, my lord, may I take your lordship to page 42, ma'am. Para 3 of the writ petition. My lord, initially, my lord, she was appointed as contingent LDC in the year 1995. My lord, kindly come to para 3, my lord. It is subject, yes, my lord.
But there must be some appointment order.
Yes, my lord. That is there, my lord. Actually, my lord, while filing this writ petition, my lord, these orders was subject matter of writ petition number 378 of 2001. My lord, kindly come para 3, my lord.
That is there.
Yes, my lord. My lord, bottom.
LDC.
Yes,
So at least in the petitions or in this data page, there's no document showing that you were, you had an appointment order.
my humble submission is my lord. This, my lord, documents, my appointment order is subject matter of my lord. A subject matter in writ petition number 378 of 2001, my lord. And that is not disputed, my lord. And even though, my lord, for the satisfaction of your lordship, my lord,
See,
yes, my lord.
there cannot be a presumption that there's a appointment order, because
Yes.
appointment order would be. You have two things.
Ma'am.
Number one, you are appointed to contingency. Contingency appointment in LDC, it's something you don't know about. You can appoint, you can be appointed as a contingency and be given any work. But to be appointed in on contingency to an LDC, that's something can't just accept it without any document.
Yes, ma'am. To,
The second part is,
yes, ma'am,
once you are appointed as an LDC,
my lord.
then the question of having 1/30 of pay as per the will never arise. That is never under protest. That the salary being given under for group D under 1/30.
Yes,
for
my lord.
counter one, it was never objected to.
Yes, my lord, that is true, my lord. And initially I was appointed for 89 days on a consolidated pay of, my lord, my lord, there is a fixed payment. Thereafter, my lord, before that, my lord, may I take your lordship to, my lord, to clarify my statement, may I take your lordship to page 105, my lord. It is a document. 105, 105, my lord. And it is document, is their documents, my lord. Wherefrom it can be inferred, my lord, that I have appointed as LDC, my lord, initially, my lord. Page 105, my lord. It is started as for the instruction above, details of Srimati G. Tiwari is given below for the further necessary action and order, please. 1, serial number 1. She is joined in marriage as a LDC in HMC on 27/11/1995 by the office order number such and such, dated 24/11/1995. Contingents basis, and she was transferred to establishment section in 14 July 1997 as Hindi typist. And she was terminated all of on 26/4/1998 without assigning any reason, my lord. My lord, this is a document, my lord, which is, my lord, with them, my lord. This is the document of appellant, man. It's not my.
एक चीज सोचो, हिंदी टर्पिस्ट और एलटीसी जो एक ही वो सर नाम से बोले, वही कर लिया, पैरा 7 में जाएगी, जजमेंट का पैरा 7. $128.
You see, they stand in the affidavit in opposition at page 115.
115, yes, ma'am. My lord, that they have not been denied, my lord.
No, paragraph 10. Petitioner's case was considered in A has been upgraded to temporary status since there's no post of Hindi typist come LDC status, therefore a grade pay cannot be raised to 1900. Therefore, if you don't have a post, you can't have any grade. Because the court in exercise of 226 cannot arrive at a finding that these two have the same status, same grade. There is something in 226. We can't extend the jurisdiction to.
May take your lordship to board decision, earlier board decision, wherein my 138 status is given to me. My lord, page 69. How they have arrived, my lord, to give me the status of 138, my lord. My lord, relevant page is at page 72. Page 72, my lord, the committee observations. Page 72, my lord. Yes,
72.
it start from my lord, page 69. Relevant
Yes.
is page 72, my lord. Committee's observation. May I read, my lord? The committee, after going through record, deliberated at length, and the observation are given herein under. As per Honorable Court order dated such and such on petition submitted by Srimati Tiwari, she was allowed to continue her service in the institute on contingencies since 23rd 2023. In the line with the court order, the committee opined that the period of Srimati Tiwari's litigation, that is such and such to such and may be considered for regularization of her services in the institute with the employees of similar period public status. B. Malay. In the light of withdrawal of litigation by Srimati Tiwari and the directive received from MHRD, the competent authority may consider Srimati Tiwari's case for enhancement of her pay at the rate of 1/30 of the scale of regular LDC post plus DA. That is 3050 plus DA with effect from the date from which the other employees who have been given the benefit of 1/38 plus DA benefit during Tiwari's litigation period for the further disposal of the matter. This is also in the line with the rule that if the nature of the casual worker and regular employees is same, casual workers should be paid at 1/38 of the pay of minimum pay scale of regular post plus DA. On the basis of this finding of the board, I have been compared with status of 1/38. Status, giving me 1/38
You see,
pay scale of LDC.
everything gets directed by page 56.
My lord.
Is the earlier judgment of this court 2002. See the third paragraph, the respondent shall consider for regularization as and when sundry procedures are considered for regularization. The so and so, till such time the petitioner's case is considered as has been directed above, she shall be allowed to continue to remain in service as on today and shall not be replaced by another ad hoc employee. Therefore, your ad hoc appointment is given the seal of approval of this court.
My lord,
So if this status remains, then you can't have a great pay.
so my lord, I beg your pardon, my lord, which page, my lord?
Page 56.
Page 56. My lord, the Honorable High Court's judgment, my lord.
So in your first round of litigation, when your service was terminated,
Yes, my lord.
after service, this order was passed and this confirms your status as an ad hoc employee. But then only that principle of existing comes that you will not be replaced by another ad hoc employee.
Yes, sir.
So this is a finding of fact. So once the court approves the status of yours as an ad hoc employee, the question of you being appointed as a LDC come Hindi typist mean that it was a regular appointment. That can't be there. So it's only when the question of regularization is taken up, then the court directs that your case of regularization be taken up.
One of the
Case was withdrawn.
since 2000.
Fifteen five 2013 losses.
Yes. Temporary status.
Page lordship 28, annexure 8 of
My lord, the annexure at page 28. Yes. My lord, this is temporary status given to me. My lord, this is regarding 138 status of the writ petitioner. My lord.
temporary status.
Page 28, my lord. Yes, yeah.
After page 28, we come to page 100.
100, yes. This is regarding temporary status.
Because
Page
this
100
is-
is temporary status.
You have no grievance with that.
My lord, regarding this, my lord, grade of payment. Yes, I have to grade on.
You have not challenged this. Neither page 28 nor page 100 is under challenge. By 28 and 100, you are attached with a scale of pay. You are now trying to attach that scale with the temporary, with the ad hoc services you were doing. Whether that is permissible. This is a fresh action. We'll forget everything. This is a fresh action.
Yes,
Now you are trying to equate that with the ad hoc service initially. Then you became a Hindi typist. Where is the material on record to show that Hindi typist and LDC are same, except the prescription made in their board of? Where is the material? That Hindi typist and LDC are one and the same.
my lord, so regarding that, my lord, this writ petition, my lord, this earlier writ petition, my lord, which was filed in 2001. my lord, since my lord, in categorically in paragraph 3, my lord, we have made awardment, my lord. These documents are part of, my lord. My lord,
It
that
cannot
has
be.
been, and
This is 2013 and the 2013 document. 2013 cannot be in 2001.
my lord, in my lord, in my writ petition, my lord. Though, my lord, this order, it's a, the passing of this order has not been prayed for, man. But I have prayed for issue mandamus, page 52, man.
And you see,
Page 52, my lord.
please come to page 122. This court has already recorded that finding. That against so-and-so dated last 5 lines, 29/8/2013 issued by registrar, the petitioner has no ground to grievance about the upgradation of a service status, but is aggrieved by the fixation of a pay.
Yes, ma'am.
So that is the only, we're trying to link page 28, page 100, and then 122. So therefore, you don't find that there are any materials on record.
My lord, there's in my humble submission, my lord. My lord, in this, my lord, the it's order which is under challenge, my lord. Page 5 is missing, my lord. My lord may be noticed, my lord. The order of landless single judgment, which has been challenged by the appellant, my lord. Page 5 is missing, my lord. I have a copy of page 5.
Para 4.
Yes,
page
my lord.
5, para
Page,
Page 5 is there. We have a copy.
We have a copy.
122, page 4 of 12, my lord.
Yes,
Para 4 is in page 5.
we have this page 5. For page para 4, page 5.
Mr. Lambu, you just see whether para 4.
Paragraph is not with me, my lord. That's
not
why
with you. You have a
it's okay.
copy, fine. It's your judgment, you should have a copy.
My lord, para 4, my lord, there is categorical finding of this.
Okay, ये पूछो LDC का पेज जब भी रिवाइज होगा हिंदी टाइप इसका पेज रिवाइज करना है इसके बेसिस पे इसमें to maintain clarity and correct.
Because if there is no post of Hindi typist, question of equivalency will never come. Even the court cannot issue a mandamus that you create a post and then adjust her. At best, the court can only say that you create a supernumerary post and give the benefit until the absorption or something.
My lord, in my humble submission,
Status. But we can't.
Yes, got it.
in my humble submission, my lord, initially petitioner was appointed as LDC man. That was not disputed by them, man.
We'll tell you what has
Thereafter, my lord,
happened.
he was passed.
Our impression of what has happened
Yes,
is
man.
that you worked for some time and therefore there was a repetition and therefore the management took a decision that we'll adjust you.
Yes.
And therefore in the manner of adjustment, they gave you this LDC 130 and then they adjusted you in a post of Hindi typist which was never there.
Temporary status.
Temporary status was still there, but you were attached as the Hindi typist, which post was never there. And thereafter the management takes a decision of interpreting the OM, which is apparently incorrect. But you accepted it because of the fact that there was no other way for you but to accept it. And later on, after 2 years, you find a repetition that your grade may be upgraded and you will be treated equivalent to an LDC.
My lord, kindly,
It's something which
appreciate,
can be done.
kindly appreciate, my lord, after my appointed as a Hindi typist, my lord, what is the claim of the writ petitioner is that, my lord, the work, nature of work, my lord, LDC and my lord, this Hindi typist is same, my lord. That's why, my lord, this, my lord, she has claimed for 138.
And just give an example. My examples are always horrible. I can't claim to have a better example in mind. one of the horrible examples, but still it is an example. You see, every dictation I give, my secretary takes it. And then she's of the view that, well, what will he does do? It is everything hard work I do, and then I get it typed out, and then only his judgments are reported. So therefore, I am doing an equivalent work. Because the honorable judge, while giving the dictation, makes so many mistakes. I correct the English, I correct the grammar, certain things, certain documents he doesn't refer. I have to find out from the records and give the dates, correct the facts, everything she does. Correct. Without her, we can't function. Therefore, she says that please give us an equivalent grade because of the fact that we do the hard work. The judge gives a dictation, goes out at 5 o'clock. I'm here till 8 o'clock typing, they're doing every hard work. So whether that's a criteria for assessment of equivalency, what is an equivalent work? In this case, can we adjudicate? Let us see this. This is a case which is before us.
My lord,
And we are asked to determine whether the work done by my secretary is equivalent to one which is being done by us. Horrible example.
yes, ma'am.
I may be excused for it.
My lord,
See the parallel.
yes, ma'am. My lord, that has been assessed in phase 69 in my humble submission. ma'am.
69.
That is board my binding, ma'am. That's why 138th status has been given, ma'am. Phase 69, ma'am.
72. 72.
72 is the operating, ma'am. My lord, in my humble submission, that has been assessed by the board.
But this is
Board of
neither
Directors.
here nor there, mister. This does not give you any right. You get my point? This does not give you any right. You can come to para 7 of the judgment. No? Come to para 7. Huh?
Yes, ma'am.
Have you seen it?
Yes,
In the middle of that paragraph, what follows? Right? Thereon would be that whenever the pay of LDC is revised, the pay of Hindi typist has to be revised at the same rate to maintain parity and equality. Now you show us any material available other than that both Hindi typist and the LDC by the 6 pay and the 7 pay were given the same grade pay.
my lord.
Because Hindi typist is a feeder post normally for promotion to LDC. Normally, normal departments. Typists, from typist, senior typist, then LDC. So show us only because of that action, whether we have to now ask them to continue as the LDC scale point.
My lord, in my humble submission, there is no, my lord, I will admit there is no RR, man, regarding this LDC and also. But my lord, that is not a part of record, my lord. If lordship permits, man, I will place one, my lord, RR. Well, this LDC and Hindi typists are shown as an analogous post. My lord, that is not a part of record. I will, if your lordship permit, my lord, I will try to, my lord, appreciate this.
No,
There is RR, one RR.
You may have strange things in various service rules.
Yes, ma'am.
Let us say that the government in its all wisdom brings out a rule for service of a particular branch of service, saying that the typist and a junior engineer is same category. Let us say that the government has done it in one of the case. Now, can in any other works department, people can come and say that, well, LDC is equivalent to the junior engineer in this particular department, and therefore please treat us equivalent. It's a policy decision for a particular department where an LDC is made equivalent to a junior engineer.
Well, that I admit, but my lord, my
Now, what happens if we
Yes,
find out any service rule where the LDC and this typist are way behind? One has 1,000 and one has 1,500. Let us say,
The promotion.
my lord,
or where somewhere there's another scale coming in between, which is a promotional post. So therefore, it's a two-tier promotion.
My lord, my lord, I'm perceived your lordship very well. I understood, man. But my lord, my lordship has made one query regarding this paragraph 1.3 of my lord, this writ appeal, man. And by that, my lord, it was submission of my learned friend, man. They have made a mistake, man. But in my humble submission, I would say that is not a mistake, my lord. My lord, they are before, my lord, come to any finding, man. There was deliberation, man. Thereafter, only this, my lord, 138 status was given to the contingency staff of the narration. That, my lord, page 26 is there, man. Page 26, man. May I take your lordship to page 26, man? This is not, my lord, mistake, I will say, man. I will submit. And my lord, and this is, my lord, not brought before net single judgment. And they have taken up it in appeal, man. This is not a part of my lord writ petition, man. This is man. Even though, my lord, for the satisfaction of your lordship, man, may I take your lordship to page 26, man.
Page
Page 26, my lord.
26.
Yes, my lord. My lord, the bottom item number 75.09 to consider conversion of concerned employees from 138 to temporary status. Therefore, the note is there, my lord. NUEA and some of the beneficiaries have demanded for conversion of concerned employees from 138 to temporary status. There is provision for casual laborers to temporary status scheme in Government of India 1993. However, casual laborers who join after a specific date were treated as 138. This institute has 21 number of 138 casual workers who have rendered yeoman service during the last 2 decades for the institute. Therefore, it is proposed to convert employees to temporary employee and to provide minimum facilities as is provided to other status employees. The proposal here. Their resolution was there, madam. This is important, madam. The board noted that the reason of giving temporary status to the employees of the institute who completed 240 days is 1/01/09/1993. It is also noted that another category of casual workers, 22 numbers, were given 138 status. After careful examination, the board approved the conversion of eligible person in 138 status of temporary is proposed. The board directive will be not cited as precedent in any other case. The BAO reiterated the earlier decision that henceforth not made by the institute. This has been done after due deliberation. And my case has been also considered directors. Now, my lord, they are saying that there is mistake. In my humble submission, there is, I don't find any mistake. What is the finding of the board? After deliberation, my lord, that this resolution has been passed. One-time relaxation. I will say, my lord, is like one-time relaxation.
You see,
Yes, ma'am.
just interrupt you for a moment. You are the writ petitioner.
Yes, ma'am.
Therefore, if you say that your work is equivalent to that of an LDC, you have to show us how equivalency, if you are trying to establish, you have to establish it with certain materials before us.
Yeah.
What is the work of an LDC in the nearest, and what is the work of a Hindi typist, and how like mason A mason does the work and he needs a helper. Helper also does the same nature of work. Just as a mason, if he is a painter, you have a helper. Almost similar nature of work they do. One will paint, the other will give this roller. Almost equivalent work. But still, they are two different categories. Now, it is your burden to establish that they are doing the same work. Because a typist and an LDC, in some cases, they may be a LDC come typist. We understand that. But what is the nature of work of an LDC? And what is the work of a typist?
Hello, in that case, my lord, if your worship permit, my lord, I will bring record my lord, the documents, which is, my lord, part of record of writ petition number 378 AP of 2001. I would like to bring that in record, my lord. Because, my lord, that is not with me now. But, my lord, in that case, my lord, these things are deliberated, my lord, regarding my appointment, my lord. Initially, I was appointed at LDC. Thereafter, I transferred as a Hindi typist in Hindi cell. That all documents were part of record in this writ petition, which was filed in 2001, which is not part of record in this present, my lord.
No,
writ
those things
petition.
are gone because of the fact that the court in that case gave a verdict.
Yes.
And it did not consider those documents to say that your appointment was a regular appointment or you were appointed as an LDC.
Yes,
Your status was confirmed as a ad hoc employee.
kindly, my lord, appreciate, my lord, that, my lord, order, this 2009, so 2001 writ petition was, my lord, disposed on motion stage, my lord. It was disposed in motion stage.
No, whatever be, you see that, but you see, I will show something to you. Those books always keep it here. Evidence Act, CPC, CRPC, keep it always here. Don't remove those books here from here. Evidence Act. Evidence Act. This CRPC.
CFTC, IPC, evidence, and CPC.
We are being highly technical. Yes, ma'am. But your submission prompted us to be so technical. You see, the principles of the Evidence Act, when it comes to relevancy of a judgment, as between two parties, you were the litigants in the earlier litigation also. So far as you are concerned, the judgment which was delivered in 2002 is binding for all purposes. Correct. So therefore, principles of res judicata, constructive res judicata, the principles of issue estoppel and other estoppel, they would all apply to both of you. Now, even if in a motion stage a case is disposed of in 2002, but the fact remains that your status was declared. An opinion was rendered in the earlier petition that your status is of a ad hoc employee. Therefore, no amount of what you call the argument can replace that fact that the issue attained finality so far as your status is concerned. Then there's a change in status that you were appointed as a under 1/30 scheme of the government as grade as class D employee, but you were given a status of Hindi typist. Correct. Now, unless you can demonstrate that that was legally permissible when this this cadre was not even there, unless you can convince us that it can be that there is a post of Hindi typist, therefore no amount of designation given, LDC come typist or any other nomenclature given to your appointment would not convert it to a post which does not exist. Correct. So I'm being highly technical. I hope you are following us. What we're trying to say. Therefore, insofar as you are concerned, you can't take help of the previous litigation and reiterate it again because of the fact that at that point of time, the challenge was only for survival. Ad hoc employee must remain and not be substituted by any other ad hoc employee. So that was an issue of survival then. Now, when you were given a great pay, then it came for increase in status. Or raise in status, not increase, raise in status by getting a great pay. So therefore, you see the question of equivalency cannot even arise because of the fact that the nature of challenge made here is not to ask this court about about the, let us see your prayer here,
Page 50.
page 52,
My lord.
is only to refix the pay. You not only spelled out, you have not spelled out that it's a case of equal work, equal pay, or the equivalency of the post. So it is in this context we are asking you. So we think that the order of this learning simulated has to go. We can only request the authorities to consider her grievances in accordance with law. And perhaps taking into consideration the long service rendered. The determination order is there. We will pass orders in the chambers.
My lord.
You may get it uploaded only day after tomorrow, because tomorrow is a holiday.
My-
Shows are disposed.
Obliged. Deeply obliged.
Deeply obliged.
CC by 2021.
Applicant. Hello, this is the appeal against the order passed in 12/6/2023 in WPC number 516 in 2019. So, my lord, without hitting into the bush, I will take to the, my lord, impugn order in the writ petition. So may kindly come to the page number 29. Twenty, 29, my lord. It is start from 28, my lord. The particular impugn order has been reflected in the court order. My lord, page start from 28 in single line. My lord, got it? Srimati Munshu Borang, senior UDC who has completed 14 years of service in the grade and in page number 29 was directed to submit the educational qualification and the NOC vigilant clearance for 2 times in the term of the office memorandum wide number such and such dated 28/1/2014 and dated such and such regarding the fixation of the graduation bachelor degree as a basic education qualification for the promotion group B. Srimati Mumshu Borang, UDC submitted the Xerox copy of class 12 pass certificate only, but she failed to submit the required educational qualification and others. Therefore, the board did not recommend her case for the promotion. So, my lord, so far this, what my humble understanding is, my lord, my case could not be considered by the department. Only, my lord, I could not produce the qualification certificates. And in the writ petition, my lord, I have successfully demonstrated, established that during the relevant at the relevant point of time, the qualification for graduation qualification was not at all required. And this has been undisputed. Therefore, now, by taking the, my lord, and others, so, my lord, the issue raised is, so far qualification is concerned, my lord, that qualification was not necessary at the time. So the others document,
You are in which class of post? A, B, C, D? You are in which class of post?
my lord,
Your post is of which class?
group B, my lord.
Group B.
Assistant, my lord. I was in the, my lord, Peter post, that was in the UDC. And this UDC is the Peter post of my lord, assistant. So the promotion, the question
You
is this
you were
post
appointed
is-
when? What is the date of your appointment?
my lord, so far the length of service is I have already enough length of the service I have already attended in that Peter post.
2004.
Now, my lord, in
Where is your writ petition?
my lord,
Where is the prayer in your writ petition? Which page?
application is in phase no, my lord, 1. My lord, being aggrieved of that, I have submitted the representation.
No, this is okay. What is the prayer in your writ petition? We wanted to see that.
Yes. In page number 59, my lord.
59.
Page number 59 and
No,
My lord.
59 is a representation. Your prayer in the writ petition, where is that?
my lord, representation in page number 59.
Prayer in the writ petition.
Prayer in the writ petition, well, my lord, find in Page number 45, my lord.
But you see, Mr. Modi,
Ma-
please come to page 50.
45 and my lord.
Come to page 50. This 50 is an office memorandum of 2014 where for direct recruitment and for promotion, what you call the bachelor's degree is a requirement. Now, you are trying to say that in 2004, when you joined, the basic education qualification was class 12. And therefore, you should be considered for promotion on the basis of that educational qualification.
Yeah.
But this office memorandum of 28/1/2014, which curtails your right, has not been challenged.
My lord, there, my lord, I'm on the way to my lord this point, my lord. So, my lord, this 28 January to, as per this 28 January 2018, my lord, page number 50, they say that right from this day, in the post of Group B will be also, my lord, that graduated. But thereafter, my lord may kindly come to the page number 52. And I will take the lordship to the 53. This corrigendum was passed by the government of Arunachal Pradesh, whereby the my lord
We are admitting it. But Mr. C. Modil and counsel for the appellant also heard Mr.
Look, I appear for respondent number one.
M. Kato and
N. Ratan. I appear for one.
here for one, for Mr. N. Ratan, then additional advocate general. For respondent number one, for education department, who is there? Mr. T. Tagam, then standing counsel for the education department, appearing for respondent number 2 and 3. And
I'm
here
the
for 4.
respondent number 4.
And Mr. M. Kato Leonard, counsel appearing for respondent number 4. In view of the grounds taken in the memorandum of appeal, this appeal is admitted for hearing. An expiration notice without requiring the appellant to take steps as all the respondents are represented. You have received extra copies?
Well.
It's submitted at the bar that extra copies of the petition has been furnished to the learned council, learned state and departmental council appearing for the respondents. Next paragraph. List on. After how much time?
2 weeks, my lord.
List after 2 weeks.
In supplementary column, my lord. In supplementary column, my lord.
Will come. Wherever it
Hearing
comes.
flow. It will come automatically.
My lord. My lord, I am appearing on behalf of Mr. T. Tang, my lord. He is for respondent number 2, my lord. Yes, my lord.
The conducting counsel is out of station for some medical reason, man. Conducting counsel for respondent number 2 is out of station, man. The matter may be at June for today, man.
I'm
Ne-
put appellant, Your Honor. I'm put appellant.
Next week, man. Next week, any date, man. Can it be on 29, man? 29, man. All right.
May I please, Your Lordship? Lordship, I beg to mention item number 5, 6, 7, and 8. These are all connected matters. Lordship, actually in this case, in item number 6 and 7, Mr. R. Sekia was the leading counsel. But due to some problems, he could not come today, and I was supposed to take over, but I'm not very well prepared today. So can it be taken up after a week?
Yes,
I have taken consent from the other side.
all sides are represented on the prayer made by Ms. Anne Dungeon and counsel for the petitioner in WBC 539 of 2023. All the matter stands adjourned today, list after a week.
Lordship, oblige.
Any interim orders are there?
Sorry, there is an interim order.
Okay. The interim order passed today stands extended till the next date of listing.
Oblige.
Malad, may I mention item number 12, Malad?
Yes.
Malad, in this matter, Malad, I'm sorry, Malad, I could not able to communicate to the respondent department at Delhi, Malad. So therefore, Malad, I have taken
No,
the
there is a issue here, just a moment. Item 12. Yes. Malad.
only affidavit to be filed, Malad, by the Union of India, Malad. Item number 12, Malad.
No, just a moment. Because this is a 2020 matter.
Child adoption case, Malad. Matter pertaining to
You see, why I track this record is that on several occasions, respondent number 1 and 2 was unrepresented. On many occasions.
Malad.
On many occasions in this writ petition, respondent numbers 1 and 2 was unrepresented. And then we've been granting time after time
Malad.
for you to file an affidavit.
Malad, I'm sorry, Malad. This times I could not able to communicate to them. In fact, Malad, the officers have keep on changing whom I made communications, Malad. So, since Malad, I've taken the consent of the other party also, Malad. At least some more time may be granted, Malad. In the meantime, Malad, I'll finalize with the Malad, the respondent authorities, whether they wanted to file affidavit or not, Malad.
But I don't think your department will be contesting this matter. This is relating to adoption.
Adoption, Malad.
So you see why it should be kept pending for 4 years. I don't understand this. What will you do in your affidavit? Somebody wants to adopt. And you see, we are troubled by the delay in this writ petition for reasons which are obvious. You know the story. You are aware of it or no? You're not aware of the story. A small child was left abandoned in a jungle
my lord.
that was mauled by wild animals. This lady, while traveling by the road, found the abandoned child
Yes, ma'am.
and brought it home, give her medical attention for more than 1 month in one stage, and again 1 month. I think 2 months, the child was hospitalized. The lady says that she has developed a bond and wants to adopt it. In this case, I took up this matter. It came to my board for determination. There was an objection by the women's some center over this
Child Welfare Committee.
child welfare committee. They objected to it. We took an exception to their objection. Now, does the government of India want that the child should be left abandoned and left to die in the road, in the streets? And then you will pay compensation? So somebody has done a good job of retrieving a half moral child from the jungle and now wants to adopt it. And now the Union of India does not have the response, as if you are contesting that. Now,
But-
who has told you that you will be contesting?
My lord, our whether my lord, my lord, objection raised by the District Child Welfare Committee will be valid or not, my lord, that is the my lord, since.
That you will decide. Union of India will decide.
No, my lord, that is the my lord, only because of that reason, my lord,
No,
notice are being
why should
issued, my lord.
Union of India take an adjournment.
My lord, the Union of India much have no role to play, my lord, other ways also, my
Therefore,
lord.
if we grant an adjournment, please tell us how much cost.
My lord, now the
5 lakh rupees?
my lord, child is in the safe custody of the petitioner, my lord.
Then that's okay. But for causing a delay, you see, I want to be a father. Correct. I want to adopt a child.
My lord.
I am not saying I will be personally interested. Let us say X is a father, wants to adopt a child. By the delay cause of 4 years, the fundamental right is not infringed. So 2020, now we are 2024, 4 years, 1 lakh rupees per year cost on the Union of India to be recovered from the personnel who has not given you instructions.
My lord, in other ways also, my lord, the affidavit may not be required, is because the my lord,
Then
yes,
we are asking you, what will you contest in this writ petition?
my lord, we are not, my lord, just instructions to that
No, no,
effect that
we
whether
close your-
the objection raised by the
Close
Child
your-
Welfare
no, no,
Committee is.
We can't permit that.
My
It
lord.
affects the fundamental right of a citizen. Either you say you adopt or you, in the day one, you say don't adopt. But with a child of this description, which I am saying, it shocks the conscience of the court.
My lord, in
Nowadays, people care for street dogs. The street dogs in the Itanagar city is biting people.
Right.
That's a frontline use. For that, people are moved. But when it comes to a child who has been picked up by a woman, saved and brought up in her home, now the Union of India is trying to come in between and then say that no, we want to file an affidavit. What will you do with your affidavit? If we permit you, you have to pay for cost of rupees 4 lakh, or we'll write that we'll close your option. It can't be permitted. You can't take this for granted. It shocks the conscience of the court.
my lord,
Somebody is bringing up a child who was abandoned. And this Union of India, the government comes.
my lord, in
wants
that
to
case,
come in
my
the
lord,
way.
may I pray then, my lord, then, my lord, in that case, my lord, I'll take instruction, my lord, small instruction, my lord, that matter may be, my lord, closed, my lord, is because, as my lord, my view is also, my lord, the affidavit may not be required, is because this has been done by the, my lord.
John,
Yes,
there's something it shocks the conscience of the court.
exactly, my lord.
It has to take it on a day-to-day basis.
Otherwise, my lord, with the Union of India have no, my lord, any objection and any role to play, my lord. This is the Child
You
Welfare
make it
Committee
clear,
who makes
you get it by Monday. Whatever you want to do, get it
My
by
lord.
Monday.
by Monday,
And we'll make our view very clear.
Monday.
I don't know. If people are not moved with this sort of plea, they'll be heartless.
Malad, the consensus, Malad, the arrive between the Malad, the petitioner is Malad, since the child is in safe custody of the Malad, the petitioner.
No, but it must be given an
Yes,
imprimatur. Somebody wants to adopt it. And the lady who has come forward to adopt, there must be some reason for the government to object just because of her background. It's a political vendetta you are trying to take against this lady. Nothing else. Just because of her background, you want to harass her. The union government and the state government, they are trying to harass this lady just because of her background. It's shocking.
Malad, basically the child welfare committee has to Malad answer that Malad, particular is because no, why
You will
the
take up the judicial side.
on Monday, Malad. Will come.
Just tell me, you see, you have so many lawyers here. Who will not be moved with this story I am saying? Had you got a child like that, reared it up? Nowadays, people, what you call, they catch hold of stray dogs and cats and treat them like their own son and daughter. In the newspapers in Itanagar, I find the obituaries of dogs and cats coming out in advertisements. People like them so much, treat them as a child. And you're not moved with a story of a lady who has adopted a child thrown in the jungle, mauled up by wild animals, give her treatment in the hospital, best of the treatment, rear it up, and then you come, the government comes in between and says that no, we want to contest. What were you doing when you had everything in your control?
Malad.
You could have, government could have retrieved it from the jungle, but they don't do it then. No, we take an exception to that adjournment. We can't take it up. That is why I have flagged this matter.
On Monday, Malad, for the proposal.
All sides are duly represented. Mr. M. Katolanet, DSGI, place on more time to obtain instructions and file affidavit in the matter. Next paragraph. The court takes an exception to the prayer for adjournment under the peculiar facts and circumstances of this case. Full stop. Next paragraph. The basic facts of this case is narrated in the order dated 29/4/2022, wherein this court had recorded that this writ petition was filed on 20/10/2020 and the petitioner herein found a 8-month-old baby in an abundance state in the jungle and brought her home, gave her due medical care and attention, and reared the child with all love, affection, and care. And she has applied for adoption of the said child. Full stop. It is because of the age bar of adoption under the Adoption Regulations, 2017, that this writ petition has been filed. Full stop. The Union of India, at the time when the child was found at the abandoned stage, did not come forward to take care of the child. And on the ground that affidavit of opposition shall be filed, adjournment of 4 years. This matter has been adjourned for about 4 years. Full stop. Therefore, the court takes an exception to the undue adjournment taken on the drop of the hat. Full stop. Next paragraph. On the long adjournments taken, the court was inclined to order a cost of rupees 1 lakh per year to be paid by the Union of India to the petitioner for the delay caused and to compensate her for being deprived of decision in this writ petition. First of, however, the learned DSGI has submitted that he would make a last attempt to obtain an instruction from the Union of India and address the court on Mondays,
27 money.
27/5/2024. Full stop. Next paragraph. The Secretary, Ministry of Women and Child Development, Government of India, is put to notice that if they fail to give appropriate instructions to their learned DSGI within 26/5/2024, and for lack of which the learned DSGI cannot assist the court, the Union of India would be ready to pay a cost of rupees 4 lakh, being rupees 1 lakh per year to the petitioner for the delay caused. Full stop. It is made clear that it is made clear that the matter would not be adjourned on the next date of listing at the instance of the Union of India. Next para. The learned DSGI is permitted to send a downloaded copy of this order
Well.
to the respondent number 1 to solicit instructions and to bring this order to the notice of the said authority. Next para. List on 27/5/2024.
Well.
When an attempt will be made to dispose of this writ petition.
Deplorable.
Madam, Mr. Lordship.
Yes.
Lordship, I beg to mention item number 23, 24, and 25. Lordship. 23, 24, and 25. Here, leading counsel K. Lolin is
Just a moment. 23,
24, 25.
24, 25. We may not adjourn it.
Yes. Leading counsel K. Lolin is got phone call from his relatives. His relatives for health problems. Lordship. He's left from court premises this morning after the Lordship.
No, but this is
So matter
2016.
may be taken up of 27 Monday, Lordship.
It's a 2016 matter.
Yes, Lordship.
Let us see item 23.
Well, in fact, this case.
Just
in this
just
case
a moment,
only.
just a moment. There's something where I could not follow. Just a moment. Who's appearing for respondent number 2? You are there, Mr. Kato,
My lord.
for respondent number 2. Where is the LCR? We'll take it up day after tomorrow.
Yeah, definitely.
Day after tomorrow, his letter of option is reflect on call list. Lordship. Day after tomorrow, his letter of option reflect on call list.
We'll be absent on 24th.
Yes, Lordship.
Okay.
On Monday, my lord, of his, he's giving
Just
consent
now.
for it.
Date is something I don't remember. Okay, 27. All sides are represented of the prayer made by land council for the petition of the matter is adjourned today. Next, having noticed that this matter is, that matter pertains to the year 2016, comma, lists the matter on Monday 27th, 5/2024.
Hello, madam.
The parties are put to notice that the matter would not be adjourned on the said date.
May I please, Lordship, I beg to mention item number 13, Lordship. This matter has Lordship fixed for 30 May, Lordship. Maybe today by mistakenly fixed, Lordship. So kindly this matter may be
This
fixed.
case, who's appearing for the prosecution in this last matter? This item 2324, who is appearing for the prosecution?
President PP, my lord.
You have seen the trial court records. You've seen the trial court records. You've seen the trial court records. You see, this the reason I'm asking you is that the vigilance took up this matter
My lord.
and the proceeding was drawn up in 2016. Correct. And the records are conveniently called here and the proceedings are stayed.
My lord.
The Supreme Court has given a clear-cut directions that the records will not be called because we are examining the correctness of an order. Why we need an LCR?
Hmm.
And nobody pointed out this trial is kept pending for 8 years.
My lord.
You should be vigilant when the records are called for in the revisional stage. Now, after a few days, no witness will be available. People would have retired, people would have died, and there will be no evidence. Very conveniently, the records are kept here. And every time the matter is being adjourned, I think you have a duty to be vigilant.
Well, my lord, if
No. You see, you are holding an office.
my
Correct.
lord, it's a simple matter. In fact, my lord, as far as
Whatever
the
be, but you're holding an office. Therefore, it's your duty to see that the trial goes on. If the records are called for and kept in this court for like just like that, you could have informed the court. We could have get the scanned copy here and send it. The correctness of the Jima
my lord,
order has got nothing to do with the trial. When
Exactly.
the trial is held up,
exactly, my lord.
then this way, when we see records, we flag this item. It can't be adjourned like that. Correct.
My lord.
Please be vigilant. In criminal revisions, in criminal, not begin criminal appeal against the final orders. If an interrogatory states the records of criminal trial is brought here, so it will be, it will delay the trial.
In fact, my lord, I was of the opinion that my lord, today itself, if, the matter could have been closed, my lord.
It is hardly, it will hardly take any time to dispose of the matter, but still, it's pending for last 2016. Yes, yes. It's not
Madam, I
yet
put a petitioner in the item number, madam, they connected.
No, whatever be the reason, you see, but it is the trial court records are here. I'm only on that. I'm not on the merit of your case. Merit, you may have a good case, you may have a bad case, we don't know. Merit is not we have examined. I'm only aggrieved by I'm hurt by the fact that the trial of a criminal proceeding is kept here by calling for the original records. In the meantime, trial could have taken place.
My two, madam, the business account has been deep, freeze still, madam.
That's okay.
So only penalty-
We know the story. The lesser said is better
Well,
today. Lesser said is better today. But
Monday.
on Monday, my lord.
yes,
Lordship, I beg to mention item number 13, Lordship. This
Item?
today wrongly listed, Lordship. This have
Item?
to list, Lordship, 30 May, Lordship. This matter has fixed, Lordship. So this matter may be kindly list again 30 May, Lordship. My humble
item
prayer.
10
Yes, 13, Lordship.
on 13,
Uh,
30.
Yeah, item number 13, Lordship. Yes,
Item 13, yes.
and this matter fixed for the 30, Lordship, 30 May, Lordship.
30.
Yes, Lord.
Okay, item 13. Just keep a seat. Item 13. Oh, no, this should come for a purpose. You're Mr. S.T. Tara.
Yes, Lordship.
And Mr. S.T. Tara, counsel for the petitioner. As the matter is listed out of turn, the respondent number 7 is not represented. Next para. By order dated 25/2024, this court had directed the Lawazima court for passing appropriate orders as regards service of notice on respondent number 9. Full stop. The matter has been listed at the instance of the registry, and it has been pointed out by the registry that by virtue of notification number 56 dated 15/9/2006, there is no Lawazima court functioning in the permanent benches of the Guwahati High Court. Full stop. Therefore, that part of the order in paragraph 4, as contained in paragraph 4 of the order dated 25/2024, is not implementable. Next paragraph. Therefore, the appropriate orders as regards service of notice on respondent number 9 shall be passed by the court on the next date of listing. Next, list on 305/2024.
Team Chief Lordship.
My lord, I beg to based on act number 14, my lord, here,
Yes,
here, my lord, this matter may be listed after 3 weeks, my lord. I could not receive the parawise comment from the department. I've taken consent from the other party
taken
also, my
consent. Okay. Both sides are represented on the prayer made by Mr.
T. Tagum, my lord.
T. Tagum, the standing counsel for the Education Department. The question is adjourned today. List after
3 weeks, my
by which time the Education Department shall file their affidavit in opposition.
lord. Deeply applied.
Any interim order is operating?
My lord, there's no interim order, my lord. No interim
No
order.
interim.
My lord, may I pray that the item number 11 may be allowed to be withdrawn, my lord. Since the petitioner don't want to pursue the matter further, lord.
Pardon me?
The item number 11, maybe allow me to withdraw.
Give the second file. Your prayer for withdrawal will not be permitted without a application. Allowed. On oral prayer will not allow you to withdraw this writ petition. This writ petition was filed by two people,
Yes, my lord.
correct? And
Yes.
your wakalatam is only for one person.
My lord, earlier this learned, this is a leading counsel, A. Sarin. Since A. Sarin has been already employed in the district legal
No,
service.
no, we do not know. You have not made a prayer for amendment of the writ petition. So therefore, technically there are two people on record. We can't permit you to withdraw on the prayer made by one. We can't permit that. Your name is
N. Tanya, my lord.
N. Tanya.
Tanya.
I heard Mr. N. Tanya and counsel for the petitioners. And Ms. R. Basad and the government advocate appearing for the state respondents. Next paragraph. The learned counsel for the learned counsel for the petitioners has made an oral prayer for permitting the petitioners to withdraw the petition. The oral prayer to that effect cannot be entertained as the wakalatam filed by the present counsel, namely Mr. N. Tanya, is signed by only petitioner number 1, but not by petitioner number 2. Full stop. Therefore, the petitioners may be well advised to file an application, appropriate application before the court if they desire to withdraw this writ petition. Oral prayer is refused. List after
This after, my lord, after 1 month, my lord.
list after 4 weeks. Yesterday, that's why we told you.
My lord.
Yesterday, that's why we told you that your prayer, oral prayer may not be allowed. You remember?
My lord,
Yes.
with question from the other side, my lord, I beg to mention item number 3, my lord.
P.
In this matter, my lord, I am supposed to file affidavit in reply. My lord.
On the prayer made by learned counsel for the petitioner, understands that John Penny petitioner to file affidavit in replying the matter. Yes. For government here there, our government is present. Next, this
After 3 weeks, my lord.
3 weeks.
My lord, interim order is there, my lord. It may be continued. Oblige.
May I please your lordship?
Yes.
Lordship, I am being aggrieved by Annexure 5, Lordship, page 25, Lordship. This is a judgment and order passed by Arbitration Board, constituted by ADC Mechuka, Lordship. Now this very order, Lordship, has been passed by the arbitration, so to say, the Arbitration Board in
Page
violation
number?
of
Page number?
page number 25, Lordship. Page number 35. It's said to be a cover decision, but it is a arbitration board decision, Lordship. It is not a cover decision in real sense, Lordship.
Yes.
This very order.
This is under which law this arbitration took place? Under AFR.
AFR, Lordship. Yes, for AFR, Lordship.
So that AFR. Anti-regulation. Which is that volume? Volume number?
1, Lordship.
Volume 1. . much less? Volume 1.
Lordship, I am before your lordship in two grounds, lordship. One is this arbitration board that has been this order that has been passed is in violation of regulation 38 of AFR, lordship. And
Let us see,
and
because
one
I'll have to go through it because I'm not well acquainted with section 38.
all right.
Yes.
Regulation 38, lordship. Subclause 1, 2, 3, 4, and 5, lordship. These
Yes.
are all the procedure that has been prescribed under this AFR, lordship. How the arbitration has to be conducted, lordship. If both the parties agrees for arbitration, lordship. Here is a case, lordship. Both the parties have never agreed for arbitration, first of all, lordship.
Okay, how was the arbitration referred?
Lordship, may I take you to lordship page 21, lordship. Page 21, annexure 2, lordship.
21, yes.
As per this order, lordship, that arbitration board was constituted, lordship.
Who's appearing for this National Highway Authority? Is National Authority a party here?
No, lordship, they are not the market, lordship.
Who's for respondent number 3?
Private
Lordship,
respondent.
respondent number 3, lordship. Lordship may kindly see order dated 8/11/2023, lordship.
8.
8/11/2023, lordship.
But we'll have to recall that order. The dusty service cannot be accepted. Although this court has accepted the dusty mode by accepting a refusal, but this order has to be recalled. You know why? You look at your affidavit of dusty service. Read the affidavit of dusty service.
Lordship, first paragraph, Lordship.
You can read this, only 5 paragraphs. It will take hardly 2 minutes to read all the 5 paragraphs.
Lordship. I, Sri Tao Tarin, son of so and so, Lordship.
Yes. Who is
do
Tao
hereby
Tarin?
solemnly
Who is Tao
Lordship,
Tarin?
He is the council, Lordship.
He is a council.
Lordship.
Correct.
Yes, Lordship.
Who is Tao Tarin? Tao Tarin is in the council. Okay. Now, please continue reading.
That I am one of the engaged counsel of petitioners. I state that I am filing the present affidavit in furtherance to compliance of this honorable court order dated order 13/7/2010. I state that I am well versed with the facts of the present case and I am authorized to file the present affidavit on behalf of the petitioner.
Yes.
That it is respectfully submitted that this honorable court in its order dated 13/7/2022 had permitted to take steps for service of notice upon respondent number 3 by Dusty Mode.
Yes.
That accordingly, as per the instruction of the petitioners, it is submitted that the petitioner number 1 went to the house of the respondent number 3 in given address to effect the dusty service on several occasions. Dated so and so, but the same has been refused.
Yes.
The present affidavit is bona fide and for the end of justice. The
Correct.
statement in this affidavit and paragraphs here are true to the best of my knowledge,
Yes.
which I believe to be true, and rest are my humble submission before this honorable.
Now, there are two or three things. Number one, we don't know whether an advocate can be instructed to serve notice. How can a lawyer become a postman? I don't know. That's number
Lordship,
one.
here,
No, that's okay. I'm just thinking aloud. Number one, a lawyer to be engaged here for appearing in a proceeding, I can understand. But to act as a postman, that's something is questionable. Number one. Second, the affidavit verification, which you did not read at paragraph 6, is that the statement made in affidavit in paragraph 3 are to the best of my knowledge. Therefore, your statement in paragraph 4 that I visited the place on several dates is not even verified in affidavit. Correct. So your affidavit is no affidavit at all. That's second. Third is that you have yourself said that the lawyer says that he went, but he does not produce anything to show that he actually went there. You see, yesterday night I had a dream that I was in moon. I really saw everything in the moon, including the Chandrayaan. Correct, but I can't give a proof of what I saw. So therefore, you don't even produce the notice of the court where you have been, by which you go to the place and then he refuses. There's no witness of a dusty service saying that you were there at the place and you could not serve. Correct. Now, interestingly, paragraph 4, instead of the word refused, you have used the word reposed, R-E-P-O-S-E-D.
Lordship, typographical mistake.
So refusal itself is not there in the affidavit. That is fourth. Next, you see, you are asked to serve notice by a particular date, by an order dated 22/7/2022. Correct?
Lordship.
As per that order, by when you should have served? (13/7). So by order dated 13/7, you were given 4 weeks time to serve. Now, can you serve him in 2023 without the leave of the court? And for 2023, did you get a new process issued by the High Court? Because in the process, it would have been written that you appear by so and so, and therefore you are serving him notice beyond the date of return. 13/7, let us say 4 weeks is 14/7, 14/8. So notice of 14/8/2022, you are serving on the person in the year 2023. Should he be compelled to appear on a back date? Supposing you get a notice today as a counsel to appear in this court on 1/1/2024. Today you are getting a notice. We are serving you a notice right now to appear in the court on 1/1/24. Is it an order which can be complied with? Can you appear in a back date?
No,
You can't appear in a back date. Therefore, your service to respondent number 3 is no service at all. So we are recalling that order. We are reviewing and recalling that order. We can't proceed against the respondent number 3 on the basis of such shoddy affidavit. Now,
Correct, Lordship.
now number 2. Have you ever seen the mode of the service of Dasti given in Civil Court Rules and Orders of Guwahati High Court? A person who goes to serve must take along with him a witness who should be a credible person, and he will also verify that yes, this man went there and he did not take notice. You did not go to his village, took a village help of any villager of that village, that you actually went there. So it's only a presumption when there is no affidavit that you went there. You don't even verify your statement by an affidavit. So we are recalling that order. You take first steps.
All right, Lordship. All right, Lordship.
Heard Mr.
J. Ginny, Lordship.
J. Ginny, learned counsel for the petitioners. So as regards service of notice on respondent number 3 by Dasti, the learned counsel for the petitioner has referred to the order of this court dated 8/11/2023, wherein this court had accepted the affidavit of Dasti service to be a good service on the respondent number 3. Next paragraph. Under the circumstances, under the circumstances narrated below, the court deems it appropriate that the said order dated 8/11/2023 be reviewed. Next paragraph. The reasons for exercising the review jurisdiction under extraordinary circumstances, which is observed in this case, are narrated as follows. Next, number 1, or ABCD, whatever. This court, by an order dated 13/7/2022, had directed the petitioners to serve notice on respondent number 3 by way of Dasti. Full stop. The matter was directed to be listed after 4 weeks. Full stop. Therefore, the period of 4 weeks would have expired on or around 12/8/2022. Full stop. The office note dated 14/7/2022 indicates that the process for Dasti was issued on 14/7/2022. However, the petitioners did not make any effort to serve notice by Dasti mode within 4 weeks time from 13/7/2022. Full stop. From the contents of the affidavit of Dasti service, it appears that the deponent who has sworn the affidavit on 26/9/2023 has stated in paragraph 4 that the said person, who is a counsel by profession, who is an advocate by profession, had gone to the house of respondent number 3 on 9/9/2022, 11/10/2022, 15/12/2022, and 5/6/2023. You have the second file. So the subpara. The nature of process which was issued by the registry for service of notice on Dasti mode is not available on record. Full stop. In the considered opinion of the court, an attempt of service of notice on a party after the returnable date is no service at all, because a person cannot be expected to appear before the court on a back date. Full stop. In this connection, the view of the court is supported by the decision of the Supreme Court of India in the case of Mrs. Nahar Enterprises, NAHER, Nahar Enterprises versus Hyderabad Alwyn, ALLWYN Limited, comma, within bracket 2007, bracket close 9 SCC 466. Next paragraph. The statement made in the affidavit in paragraph 4, in the paragraph 4 of the affidavit of the service, the deponent has made a statement that he had visited the given address on several occasions. Full stop. In this regard, we have already stated that the address in which the deponent had gone is not available on record. Full stop. Be that as it may, the statement made in paragraph 4 is not even verified in the affidavit as to whether it is true to the knowledge or true to the information received. Full stop. In the affidavit, it is not stated that who had identified the house of the respondent number 3, and there is no indication that any person had witnessed the refusal to accept process by the respondent number 3. Full stop. Therefore, the statement made in paragraph 4 of the affidavit of the state filed on 26/9/2023 cannot be accepted as a good reason to presume acceptance of the notice on refusal of respondent number 3 to accept the process. Next paragraph. It is next paragraph. It is left open to be examined in an appropriate case as to whether a lawyer can be engaged to serve notice and thereby act as a postman. It is left open to the Bar Council of India to examine whether the lawyer can be engaged to act as a postman, and whether it is befitting for an advocate to do so. Next paragraph. As there's no office note regarding reissuance of the dusty process returnable on the date when the service was sought to be made, comma, the court is of the considered opinion that this is a fit case to review the order dated 8/11/2023 regarding acceptance of service by dusty mode on respondent number 3. Post of the said order is reviewed and recalled. Next paragraph. Accordingly, the petitioners are directed to take fresh steps for service of notice on respondent number 3. Fresh steps within three working days. Service of notice on respondent number 3 by registered post with AD, as well as by dusty mode, by routing the process through the registry of the court, and upon service, an affidavit of service shall be filed prior to the next date of listing. Post of next para. The learned counsel for the petitioners is also at liberty. No, shall also, not liberty, shall collect the postal receipt number from the registry and submit postal track report prior to the next date of listing. Next, the notice is made returnable on, give a date after 4 weeks, make it 5 weeks. 27/6/2024.
Obliged, Your Worship.
Yes.
My lord, this is petition, they have not turned up. This is regarding the issuance of no NOC, my lord, no objection certificate for running the nursing classes, my lord, nursing. So accordingly, we have issued a NOC, my lord. NOC, we have granted an NOC of intake capacity of 20 intake, my lord. At page 13, they have filed the affidavit also. Page 15, my lord. Their additional
Page?
affidavit. Page 15, my lord.
15 of your affidavit.
15 of their affidavit, my lord. Additional affidavit they have filed, my lord, bringing the NOC issued by the authorities.
Where is that?
Page 15, my lord.
15.
In the interest of public service, no objection certificate issued to the Apex Professional University.
Additional affidavit file on?
They have filed it on, my lord. 4 December, my lord, 2023.
4 December
Yes, my lord.
23.
23, my lord. By Apex Professional University.
No, I don't know. This 4 December is something which is not here. There's an affidavit filed by the petitioner on 27/2/2024.
My lord, otherwise, I have a copy of NOC.
So if you admit it, then from the date of this issuance, they will be permitted in the next academic year.
My lord.
From this to admit their students. We close the petition then.
My lord, that's why, my lord. But purpose of the filing has been, my lord, this fulfilled, my lord.
Yes.
Your
Close this
lordship,
petition.
yes, lordship, actually the leading counsel is out of station. Therefore, lordship, I would kindly request to give a fixed date for the argument, lordship.
Okay. All sides are represented on the prayer made by counsel for the petition. The matter stands adjourned today. List after
After 2 weeks, lordship.
2 weeks.
Lordship, any fixed date?
You make a mention after 2 weeks, it will come.
My lord,
Normally it
my lord,
comes.
after 2 weeks.
Normally it comes.
Normally. Deeply affected.
You take back your document.
My lord.
You got it. The affidavit was filed on February, not
Well.
in December.
My lord, there may be some difference. I'll just check.
Next slide.
My lord, matter may be passed over for some time. The matter may be passed over for some time. Lord.
For some
Council
time.
is on his legs.
After some, then we'll resume at 2 then.
Of lights.
Yes. My lord, by this writ petition, my lord, the writ petitioner, my lord, there are 5 in number, my lord. Challenging the, my lord, the proposed eviction sought to be done by the, my lord, respondent authority, my lord. Without, my lord, giving opportunity of hearing, my lord, because under the Wildlife Act, my lord, there is a provision, my lord, that before carrying out any eviction, my lord, that opportunity of hearing has to be there. Otherwise, my lord, that is the principle of natural justice, my lord. That is, otherwise, a statutory law is there, my lord. So, my lord,
Wildlife Act. Wildlife Act.
Section 34, my lord, the proposed eviction is under section 34. A. A. Proviso, my lord.
Yes, no opportunity was granted. Yes,
In the notice itself, my lord will see.
madam. No opportunity was granted, Madam Ete. No opportunity was granted to the petitioner.
Lordship, Lordship may kindly come to my, Lordship. Page 26,
Page
26,
of the writ petition.
affidavit in opposition, Lordship.
Yes,
Page 26, Lordship.
yes,
Annexure 2.
yes.
Lordship, this is the first notice. They all have been given notice. Lordship got it. Lordship, affidavit filed by the respondent number 2. 2, Lordship.
Just on. Yes,
Yes. Lordship, notices have been given not only once. I have been told they have been given many notices, Lordship. It's not about encroachment only, Lordship. We have stated clearly that these petitioners, Lordship, they were illegally staying in the type 4, type 3, type 2, and barrack of the wildlife sanctuary, Lordship, buildings, Lordship. Because this one, houses, Lordship. And after staying there for many years, they have put on fire the building, all of the buildings, type 4, including type 4. And in that place, they are building their own houses now, Lordship.
yes.
Lordship, we have also stated
These
that.
all are the facts, my lord, which has been disputed, my lord, and FIR has been filed.
disputed
That's
at all, Lordship.
investigation is going on, my lord. Now, my lord, what is the case here? The case here, my lord, it is on the record, my lord, that this particular area, my lord, since it is not something, my lord, since a few days back I have started, they are staying, my lord, since 1994, some of them petitioner. RCC building already constructed, all the photographs have enclosed here. Basically, my lord, so many issues has been raised, but basic issue, my lord, right now, my lord, in the writ petition, my lord, kindly turn to page number 21, my lord, of my writ petition.
the notice,
Yes.
page number 21. This is the impugn notice which has been put into challenge, my lord. Page number 21. It starts from page number 21. Now, this notice was issued, my lord. But here, my lord, the word is that not asking any explanation from me. The word is here, my lord, whereas wildlife offense have been drawn for so and so at lobby for violation of so and so. You are accused of construction of RCC building, my lord. Now, my lord, kindly see the page number 21. RCC building I have already constructed, my lord. What my learned friend is saying, it's of a different issue, my lord. I am on the point of this particular impugn notice, my lord. I'm not for other cases, my lord. I am particularly challenging this impugn particular notice, my lord. Now here saying, further you are accused of construction of RCC, my lord has got page number 21.
Yes, yes, please continue.
You are accused of construction of RCC buildings so and so without obtaining permission. Therefore, you are directed given 30 days opportunity to remove whatever structure constructed by at your own cost, failing which necessary action shall be taken as per provision provided under section so and so. My lord, now this notice I am putting in challenge, my lord. Now, allegation has been made by the department against me that I have constructed a RCC building. I am not denying this. Since 1994, I have been staying with my family. I have enclosed photographs of my RCC building also, my lord. Now they are saying that this falls under Itanagar Wildlife Sanctuary. My case is, my lord, it falls under the municipality ward number 8. I have the documentary proof in that support, my lord. Even, my lord, their claim of this wildlife sanctuary, I think, my lord, legally will not be sustainable, even if I raise that issue before them itself, my lord. Because that is a disputed question of fact, my lord, which I am not going to that aspect. Now, my lord, confining to this notice, my lord. Now saying that, my lord, that I am staying there with my family, RCC building I have constructed. Now saying that you directly remove. Article 30, section 34A says, my lord has just gone through the provision. That, okay, you give me the opportunity, let me explain what is this, how I happen to occupy this particular land, whether this area falls under the Itanagar Wildlife Sanctuary or not, my lord. My lord, at least, my lord, because more than that issue I cannot raise. Otherwise, my lord, there are so many issues I can raise. My lord will find more than 500 households are settled in that particular area, my lord, from I am sought to be evicted. Is it, my lord, only the Itanagar Wildlife Sanctuary is only dealing with this private plot of this 5%, my lord? What about this 500 people, my lord?
Unfortunately, these 500 people are not there before us.
My lord. But my case is like
The second point is that negative equality, when
Of
it comes
course,
to
I am not
wildlife
asking.
sanctuary,
My
can't be
lord.
invoked.
Negative, I am not asking. But my lord also, my lord will consider also if it is a wildlife sanctuary, others should be also, my lord. That is positive, my lord. I am not saying allow me to be there. But law cannot be also, my lord, okay, only this 5% will be evicted from the Itanagar Wildlife Sanctuary, then it will be safe, my lord. That cannot be the also law, my lord. Let all the 500 household be gone there from. If it is so, my lord, you cannot just choose 5% from out 500%, my lord. My lord, is a highly disputed question of fact, whether this will fall under Itanagar Wildlife Sanctuary. Because, my lord, government itself has declared it as a, my lord, under Itanagar Municipality Ward 8, my lord. I have the document, my lord. All these development sanctions, culvert, road, medical.
Where is that?
My lord, I have brought in my affidavit in this rejoinder, my lord. My lord, kindly take my affidavit in reply, my lord. Straightly, I will start from, my lord, page number annexures, my lord, page number 11, my lord. Page number, my lord, this is the electoral roll for Itanagar Municipality 2020, my lord. Here, my lord, name of the 4 petitioners are enrolled, my lord. This falls under, my lord, ward number 8. My lord, will find the place lobby. Lobby falls under Itanagar Municipality Ward number 8. This is one fact. Thereafter, my lord, the petitioner's name petitioner's number 4, my lord. His name is at serial number 704. Petition number 3, my lord, at serial number 478. Petition number 2, 466, my lord, of the roll. Thereafter, my lord, land allotment has been given in that place, my lord, DC, my lord. I will show that part also, my lord. Page number 38 onwards, my lord. Page number 38, my lord. my lord, then page number 39, serial number 10, lobby area, lobby. The area is called lobby, my lord. Now, these are the, my lord, list of the people, my lord. Other people to whom the deputy commissioner has issued land allotment, my lord. These all are the list of the people. Now, my lord, that's why, my lord, even this forest area itself is in question, my lord. Then, my lord, will find, kindly turn to page number 50, my lord. Page number 50, certificate issued by the Deputy Director of School Education, saying, my lord, since 1993, in 1993, primary school lobby was established, man. This is in the same area. The school is there, my lord. Then, my lord, next page, my lord, page number 51. This health facility under are hereby notified to this health, the WC lobby, my lord. There is a, my lord, this health facilities also there, my lord, in the same place, my lord. Then, my lord, will find, my lord, page number 52 is the Google map, my lord. My lord, this is the, my lord, settlement area, 52, my lord. Page number 52, my lord. Huge settlement, my lord.
No, just a moment. This, who is appearing for Forest and Environment Department?
Lordship,
They have a separate counsel or you are
Lordship,
appearing?
Lordship may kindly come to my affidavit. I have filed for.
I'm asking a question. I'm hearing Mr. Sonar first. I'm asking a question that you are the government advocate will appear for the Forest Department or they have a separate counsel?
Yes, Forest Department.
You appear for them also?
Yes.
My lord, then page number 53, my lord.
Yes.
This is the huge settlement area where from I have been sought to be evicted, my lord. This page number 53, my lord. Then page number 54, my lord. Page number 55 is the health
No, Mr.
subsector.
Sonar, you see, when the state government has produced documents to show that this is what do you call, it's a forest land,
My lord.
then
There also I have,
whatever is the status, present status, but till the forest land is not denotified,
Well.
we will examine that if this matter can be taken up as a PIR. Because if it is a forest land, it affects all the persons in the society. So therefore, if the settlements and others, and other, what you call, the settlement process, land allotment process are done in a forest land, then everything will come into a scanner.
well, one question will be, even our, this courts, my lord, this structure, this will also come under.
No, it's okay. If we have to go, we have to go.
Because
No.
earlier it was done in the 77 part.
Unless you see, there's a, it's a very clear cut law. When a land is a forest notified land, then they cannot be any activity and therefore it has to be restored back to the forest.
Right.
So whether you are there or I am there,
Right.
we both have to go.
Right.
So we'll ask the registry to examine and register this issue of settlements being given in the forest land to be taken up as a PIR. Even if it may affect thousands of people. But we can't be.
It needs to be settled, man.
Lordship, these
And
photographs are.
Like my experience in this, my lord has expressed that whether how the land, forest lands are given allotment and settlement are being done. So that 1977, 78, all those notifications with regards to capital complex in Arunachal, in view of that governor judgment in 2006, So then subsequently what had happened, earlier it was not known to the government or even the people. They were not very conscious about the fact that there is an impediment in the form of forest land. No NOC, no allotment can be given. Now, very recently what had happened, the Arunachal government have taken a policy decision and the proposal has been sent for de-reserving those reserve forest area
where the human habitation has already been done. So that proposal, my lord, I am aware. So in the meantime, my lord, as a bona fide citizen of Arunachal, my lord, can we, for a moment, my lord, can we do not take that view, my lord? Where once it is,
No, you
one
see,
judicial
it may
one
affect
judicial
thousands
competence is
and, it can
taken, my
affect
lord.
thousands and thousands of persons.
My lord,
But the fact remains that
My-
if the, you see, let the government take a decision.
my lord.
But what is happening, whether it is right or wrong, can be examined in PIL. You will order a sumo to PIL to be registered, because this can't happen.
My lord, only I can.
My lord, there is one
I
more.
can only request, my lord, for a moment, my lord. Since the process is on, my lord. Just making a request, my lord.
No,
Otherwise-
that's okay, we have taken.
My lord,
We have not.
there is one more problem, my lord, issue here. My lord, Section 18 of the Wildlife Sanctuary Act, my lord, says, my lord, that notification has to be in terms of Section 2, Clause 22, whereby it should be in the Gazette notification. This is not there. I have so many judgment in support of that one, my lord. This notification,
That will be examined,
because-
whether it is there or not,
My
we
lord,
have to show.
that is also one issue is there.
We-
Then those
we
issues are there.
those.
This can be examined, my lord.
We can encapsulate those, because the fact remains that rightly or wrongly, when the state government comes and says it's a forest land, and you are claiming that only 5 people have been
My-
identified,
My lord,
then what is happening for others? The others are not before us.
my lord,
So we'll have it examined by the PIL committee
my lord.
and let them take a decision. in this
Lordship,
matter.
may I, Lordship. Lordship, this 500 and 600,
I agree to that
which
proposal.
he
here.
have Lordship, said is Lordship, very vague Lordship. This photograph Lordship, this Google map is, this very vague Lordship. Lordship, vague Lordship, this is.
No, Google
How
Map
do
will not
we
be
know
vague.
that there are that
Google
much?
Map-
But then these people, these very people, they are very much encroachers. Lordship may kindly come
that-
to
you
my
see-
page 32 also. GPS coordinator has also shown their places very much within the wildlife sanctuary, Lordship.
No, that's okay.
This
but
is-
Mr. Sunari
This is
raising-
within wildlife sanctuary, Lordship.
No, that's okay, but Mr. Sunari is raising issues which are more, which has to be considered.
Yes, ma'am.
He's producing documents to show that these are the municipal wards,
Yes.
area within the municipal wards. So how can the government allow a municipality to take over the forest land?
This is also Lordship. They might have put their names, but then this,
It can't,
I don't think this
can't
Lordship,
happen.
this very place is within this.
I understand, but
Lots
let
of-
me let me ask you a question. Now, today I give my address
Not,
as X so and so, resident of this what do you call, having office at Papumpare, this UPIA court complex. So and so, Itanagar Papumpare, the district, and then I say United States of America. Correct. I swear this affidavit. Now hundreds of people join me. They want to be a part of USA. They will love it more than the name of our country. They will like a foreign name. So they also agree that everybody starts saying that this is USA. Now will it become USA? Will it become part of ward number 8? Just because some people come and go and have their electoral roll notified as the ward number 8 will not crop up from somewhere. It has to be notified. A municipal ward is always notified under the municipal act, whatever act you follow. But the ward area will have to be notified. It's just somebody cannot come and say that well, I am a resident of ward number 8.
but then Lordship,
Or,
it's
uh,
very
resident-
5 people. They have built their homes where there were quarters
No, you
after
see,
demolishing the quarter, Lordship,
Electoral roll says ward number 8.
government quarter, Lordship.
Maybe you may be 100% right. But how does this ward number 8 come in existence?
Lordship, this is 2020, Lordship, but then this, Lordship, this
that means-
ward where they have
That means the municipality does not know what.
enrolled themselves is 2020, Lordship.
That means municipal, you are wanting to say that the municipal authorities are more powerful than the state government authorities.
Not at all.
State
Lordship.
government
Not at all.
notifies forest and municipal says that I take over.
All this government sanction order I have imposed, whereby all these developmental activities have been taken there. Road construction, culvert construction, all these documents have been included
Construction
here.
would be there, Lordship.
All series of
That
things.
will be there, Lordship, but then
That's why it's a settlement area.
when the petitioners came here, Lordship, before this
Two things
honorable
can't
court,
happen
Lordship,
together.
status quo was granted, Lordship. Under the Garbo status quo, they are continuing their building, Lordship. Because of that, we have filed a contempt petition also before this honorable court, which is pending, Lordship. They are continuing their construction, Lordship.
But if it is a municipal ward, why they will not carry out?
Lord,
See-
Eviction, against that eviction order only, Lordship, they are reported in the police also. FIR is also given against them, Lordship.
So you see, your stand is that this is not ward number 8.
No,
This
Lordship.
is a forest land.
Yes.
And we have documents where Mr. Sonar is saying that it's a ward number 8 of municipal land. Now, who will adjudicate?
The Lordship, exactly, he
And
is
my
not
lord
saying,
can-
Lordship,
my lord
let him show the GPS coordination, Lordship, where he is staying, Lordship.
No, you see,
What
you
it
are-
shows, Lordship.
the state is
This
more
location.
powerful than Mr. Sonar. The state is more powerful. You could have bought a GPS, what you call, location and said that it's a part of.
GPS, Lordship, is here, Lordship, in our record, Lordship.
So where is the statement? This is not-
GPS, as per GPS coordination is within the Lordship, 32, page 32.
It's okay. So therefore you are saying that the land where the house of Mr. Sonar's clients are located is not under municipal ward number 8,
Yes, Lordship.
correct?
Is
So
within
where is this municipal ward number 8?
Ward number 8, Lordship. There are so many places here, Lordship. Ward number 8, within ward number 8, ward number 8, so many Lordship locations comes, Lordship. His location,
This must be notified.
he's saying his location
Madam,
comes.
it must be notified. A municipal corporation to take over a land, there has to be a gazette notification. They just can't wake up in the morning and say that, well, I claim this land to be municipal land. They can't do it. Under the Municipal Act, there's a specific provision that the area to be included in the municipal.
But here nobody is following the.
No.
Lordship.
I don't know about nobody.
Municipal,
somebody-
Lordship. I understand.
There must be somebody who knows law. Where is Municipal Act? Ignorance of law is not an excuse
Lordship.
for the government. The only excuse of not knowing the law is available with the courts. A judge can say, I don't know the law, and I can get away with it.
Well, that is the most awkward situation in this part situations. Ma'am. Even our most of the area, Itanagar area, ma'am, all will fall if we go by the purported notification what they are
So
saying.
if it has to go, it has to go.
But then, my lord, it will
They will-
confine to a very, because it was done in.
Lordship,
It-
this
Because
is
the
but then
government is-
lawless. Wildlife
government is
sanctuary,
doing
Lordship.
action because now it has become a human problem. That's why I fully agree with my lord's proposal that has to be looked into and settled for once and all, my lord.
Because if there is a departmental dispute, then ideally it will be the chief secretary who will take up the interdepartmental disputes. Normally that is the law. In this state, if it is different, I don't know. What happens when there is a dispute between two departments? Who adjudicates the issues between two departments? In the government of Arunachal, what is the process? Under the rules of executive instructions, what is the process to be followed? In Assam, the executive rules of business says that if there is an interdepartmental dispute, then it is the chief secretary who adjudicates.
Cabinet secretary, by virtue of cabinet secretary.
Huh?
By virtue of cabinet secretary, township secretary.
Secretary,
Yes, chief secretary.
chief secretary.
Chief secretary.
So if it is the chief secretary, then nobody, neither the forest department nor the municipal department approach the chief secretary to have it adjudicated whose land it is.
Well, it is a situation is like 7 to 245. Then that when there is a interstate dispute. So that is
Mr.
referred to
Tara.
in that. And then here also,
No, Mr. Taha, the problem is that this chalta hai attitude must stop somewhere.
my lord, that
Because if it is a forest land, then we have a right to poke our nose inside.
my lord, I understand the concern of the court. Because lordship has to uphold the rule of law, but at the same time, Lord, we have sometimes have to lose sight also for the humanity, my lord.
Lordship, in the
No,
similar
I
matter,
appreciate
in the
I
similar,
appreciate your suggestion, but
this
it
court,
will be
Lordship.
difficult to follow.
But my lord, their issue will come whether correctly this has been declared or not. That is also one of the big issue here. Because this gadget notification is not there. And judgment says, my lord, without gadget notification, such forest land cannot be declared. I think tomorrow forest department will be losing all huge place, huge area.
Lordship, but then this very case is, Lordship, within the wildlife sanctuary and similar Lordship matter, Lordship. GPS coordinate was given in this case also. Lord.
Where is the document of the forest?
Map, my lord,
Lordship may come to
is 25.
page 21.
25 of the writ petition.
Yes, no, my lord. This
Affidavit in opposition.
affidavit in opposition.
Page 22, Lordship, exclusion. Lordship, for the facts, Lordship may kindly come to my para 7, Lordship. Lordship. Yes, Lordship. Yes. INC, they have their council, Lordship. They may be.
Here is, my lord, one more issue is even there, legal issue. The section 18 of the Wildlife Sanctuary Act. It says, my lord, this is they are saying, my lord, this area is Itanagar Wildlife Sanctuary Division. Now they are saying that from Itanagar Reserve Forest, they have carved out the wildlife sanctuary. Section 18 prevents, my lord, that from reserve forest, my lord, wildlife sanctuary cannot be carved out. That one legal issue is also there. This area was initially made under the Itanagar Reserve Forest before declaration of the wildlife sanctuary. It is something like. My lord, this kindly turn to page number. This is there from their affidavit itself, my lord. Kindly turn to page number annexure 1A, my lord. Page number 19. This was issued on 20 February 1978, Itanagar Reserve Forest. My lord has got page number 19, 19, annexure 1A. From the counter affidavit. 19, my lord. My lord.
Lordship, it is 21.
No, हम बता रहे हैं.
19.
19. I will come from, starts from 19. Yes, this was issued on 20 February 1978. Madam. This is, Malad, in exercise of the power conferred so and so and the Assam Forest Regulation read with section so and so, the state government has adopted and modified by the Northeastern so and so. Adoption of laws, the Lieutenant Governor hereby pleased to declare that the land described in the appendix so and so shall be a reserve forest from the date of the publication so and so. Madam. So reserve forest was declared in 78. Madam. Now, my lord, let's turn to page number. Page number, my lord, 23. My lord, type copy, my lord, will find page number 24. 24. Then my lord will find that that was issued on February. Then this subsequent notification was issued on 14 June 1978. And now this is what this notification is saying, my lord. In exercise of power conferred by section, the Lieutenant Gonso declare that it as described below and notified favor as the sanctuary. Section 18 prohibits, my lord. Cannot, my lord. This notification even violates the statutory provision, my lord. So sanctuary, I think legally not proper, not legally correct, my lord.
No. No. Can't be. What's the same point? Okay, right.
My lord. First, Itanagar Reserve Forest, my lord. Thereafter, they have carved out. Section 18 says cannot be done. And this notification is not in a gazette notification. Tomorrow, I think how the forest department will justify this part, my lord. I have our own, my lord, reported judgment from our own High Court, my lord. Says, my lord, if not gazette notification, my lord, then it cannot be said that, my lord, lawfully it has been created.
Do you have a point?
Well,
yes.
Lordship, in the same year itself, it has been redesignated as some sanctuary.
Mr. Sonan is right. 18 prohibits. It can't be in a reserved area. A sanctuary can't be declared in within a reserve area. So therefore, you'll have to produce the.
This is reserve forest has been, some person has been designated as sanctuary, Lordship.
Look at this.
then,
Lordship.
my lord, kindly turn to page number 25, my lord. Map, my lord. Just show, my lord, where is this sanctuary inside the reserve? Page number 25 of the affidavit.
25
of the affidavit in opposition.
Yes.
25. My lord, this in the middle lobby, it's written circle 1. This entire area is the Itanagar Reserve Forest. Now, sanctuary, they are saying, my lord, this is the middle one. In the middle, my lord, there is a circle. My lord has got. It's written lobby. Now they are saying that this is wildlife sanctuary, and this entire area is the my lord, Itanagar Reserve Forest. And my lord, exempted area is, my lord has seen, there is highlighted, my lord, in the box, my lord. These are the, my lord, exempted area. Now this is in the middle of the reserve forest. Now in this situation, my lord, entire our, my lord, settlement area is under this Itanagar Reserve. But forest department, so far Itanagar is concerned, he has not initiated. I am so far wildlife
We'll
sanctuary.
have the Ministry of there's a Department of Forest in the state.
Lordship, yes, protected areas, Lordship.
Huh?
Lordship,
There is a Department of Forest.
Yes.
in the state.
yes, Lordship. Department of Forest, yes.
They will add them as party, and they will produce the notification with regard to the reserved area and the reserve forest and the wildlife forest.
And for gadget notification of those things.
Both.
Legally, Lordship, that may be, but then still this is reserve forest area, Lordship. This area is, Lordship.
You see, these issues we have to go into. It's a legal issue we have to go into. You see, you are exercising power. But in exercise of the power, you have to show us that this, the number one, this is forest, wildlife reserve exists. That can only be by way of an gazette notification. Because now Mr. Sonar has pointed out with two gazette notifications. One in February, one in June.
Yes,
One says reserve forest.
yes,
Once a reserve forest is declared, then 18 comes into play. You can't declare that area into a wildlife reserve. You have to justify your action.
Lordship, all of this doesn't mean that the petitioners have any right to be there, Lordship. They are still encroachers, Lordship.
Please satisfy us that what land is this. Now there is a third class of land. You also say there is a municipal area. If it's a municipal area,
Regarding municipal, Lordship, I'll take instruction, Lordship.
no, we are impeding those the municipality also.
Yes, Lordship.
Otherwise, we can't decide these issues. When Mr. R. Sonar and counsel for the petitioner and SG-88 and additional senior government advocate
Yes, Lordship.
appearing for the respondents. Next, in course of deliberations, the learned counsel for the petitioners has referred to Annexure 1 within bracket capital A of the affidavit in opposition filed by the respondent number 3 on 22/11/2023. Oh, sorry, no, this is respondent number 2. Respondent number 2 on 11/12/2023. Which is a notification number FOR stop 118/68 dated 20th February 1978. By which an area measuring approximately 140.8 square kilometer, equivalent to 14,080 hectare land described therein was declared to be a forest, a reserved forest from the date of publication of the notification. Next paragraph. The legal counsel for the petition is also referred to annexure 1 capital B of the same affidavit of the respondent number respondent number 2, which is where is that reserve for what do you call, where is that where is that wildlife reserve? Where is that notification? Wildlife reserve.
Subsequent notification of. My lord will find page number, my lord,
23, page 23.
23, my lord.
Okay, 1B. So. Which is again a notification bearing number FOR post of 118/68 dated 14th June 1978, whereby the Itanagar Reserve Forest notified by number FOR post of 118/68 dated 22 February 1978 was declared as a sanctuary. Full stop. Next para. Referring to section 18 of the Wildlife Protection Act, Wildlife Within Bracket Protection, bracket was Act of 1972. It is submitted that section 18 of the said act bars declaration of reserve forest to be a sanctuary. Next paragraph. Municipal Act. By next one, by referring to various documents annexed to the affidavit in reply filed by the petitioner on 1/5/2024, the petitioners are projecting that the land which they are occupying is an area covered by municipal ward number 8 of Itanagar Municipal Itanagar municipality. Next one. If the land is a municipal land, then by virtue of subsection 52 of section 2 of the Arunachal Pradesh Municipal Act, 2007, a municipal, in inverted commas, a municipal area, inverted comma closed, means an area constituted as a municipal area under section 6. Full stop. The manner of constitution of municipal area is prescribed under section 6 of the said act. Full stop. Next one. Therefore, the court is of the opinion that that in order to have clarity in the matter, it would be appropriate to direct the impleading of the of necessary parties in this petition, in the absence of whom the issues cannot be decided. The parties sought to be impleaded are, the parties ordered to be impleaded are, number one, Secretary to the Government of Assam, sorry, Arunachal Pradesh, Ministry of or Department of
Lordship,
Forest is what department? What is it?
Forest and Environment, Lordship.
Forest and Environment Department.
Well, that is principal secretary, principal chief conservator of forest.
He is holding two posts.
Yes, principal secretary. He is also
Principal Secretary, come head of the Forest Force.
correct.
And who is the Chief Conservator of Forest is different.
Yes, chief conservator is.
Oh, okay. Principal Secretary. Yes. The address will be Secretary Itanagar?
No, I think.
Opposite Itanagar.
Huh?
Itanagar.
Not in the secretary, I think they have different establishments.
They have a different location.
Yes.
Just where is the location of the office?
Lordship, location as such, I think Chimpu.
Location is just before, just after, just about, if we reach to Itanagar from here,
Okay,
we take left to the Raj Bhavan,
yes, yes,
then just after 200 meters, is a forest office.
yes. Near Bank Denali.
No, I have to give an address.
Lordship, just Itanagar is will do.
Itanagar.
Itanagar.
Yes. Comment
Itanagar.
Arunachal Pradesh,
Huh?
Sector Itanagar.
P sector.
P for police.
Okay, P sector Itanagar.
Sir,
That's
0
not
point.
P, I think,
0
0 area, 0 Bank Denali.
Okay, just say Itanagar. They will find it.
Itanagar will do.
Just say Itanagar.
Comment of Arunachal Pradesh,
That
Itanagar.
is number one. Number two, the Itanagar municipality represented by, who is the head?
Lordship. Secretary, not Commissioner,
No, they
Secretary.
will not have secretary. They will have chairman or
Chairman is there.
either chairman or chief executive officer.
Chief Executive is.
Chief executive officer.
It's a municipal corporation now.
No. If it's an elected body, they will have a chairman. If the government takes over, then only there is an executive officer. Otherwise, there will be who is the administrative head?
Chief Executive Officer.
Chief Executive.
Yes.
Specified by the Chief Executive Officer within bracket by any designation whatsoever, bracket closed. Itanagar. Next para. The petitioner shall the learned counsel for the petitioner shall provide a amended cost title of the parties, inclusive of the including the two authorities who have been included as respondent numbers 5 and 6 respectively. Stop the original receipt of the amended cost title shall make it a part of record. Next para. No, full stop. The same shall be done within 3 working days.
4 days.
Huh?
4 days.
No, working days is you're getting
3.
5 days.
Fine.
Within 3 working days. Next para. Pending amendment of the cost title, comma, issue notice on the newly implemented respondent numbers 5 and 6. First of as Ms. G. Atel and additional state government accepts notice on their behalf.
Forest,
And municipality,
municipality lordship, they have a standing council. They have a standing
who
council.
is he?
Tagum Jamu, Tijamu.
Teacher, okay. Issue notice, the Ms. G. Atel accepts notice on behalf of newly implemented respondent number 5. And Mr. T. Jamo, who is the standing counsel for the Itanagar municipality,
Yes.
shall accept notice on behalf of the newly implemented respondent number 6. First of, extra copy of the registration with the amended cost title be provided to the learned departmental council appearing, government and departmental council appearing for respondent numbers, newly implemented respondent numbers 5 and 6 within 3 working days. Next paragraph. The newly implemented respondents shall produce a copy of the original gazette notification referred to herein before being same two numbers, huh? Just copy. FR 1868 dated 20 February 1978 and this FR 118/68 dated 14 June 1978. Both by the Secretary within bracket Forest, Government of Arunachal Pradesh. Most of the next by the standing council for the Itanagar municipality shall produce gazette notification relating to notifying of the land within municipal ward number 8, as well as the map of the land within the said ward number 8. Next paragraph. List on. Give a time after 3 weeks. Give a date after 3 weeks. List on so and so.
Deeply obvious.
Also, I may be provided one extra copy.
I'll give it within 3 days. They will have to amend the
Yes.
cost title and give it to you.
Yes, sir.
What is the date you are giving? 13 June. No, 13th is a hearing day. Don't give on Wednesday, Tuesdays and Thursdays. Make it 12th or 14th. 14th June, this Friday.
Lordship,
14, my lord. Out of station, I'm 17.
17.
17.
17/6. Mr. Sonar, you saved yourself.
My lord,
I had a different plan.
my
You will demolish brick by brick that plan. Because we're not concerned with how many people are affected. It's not the quantity of people affected. It is the quality of life of others who are affected. I say, is anybody taking up the PIL here for this road condition from Itanagar to this court? Is it? Nobody's taking up any PIL. It's in a really very horrible state.
Yes.
I think somebody should take up this issue as a PIL. The air quality ambience in that place is very, very bad. It will be one of the most polluted areas. And I don't know how people are living there. I'm pained to see young people, especially girls, going out with masks because they can't breathe. The one good thing I found that especially the ladies here, in that area, they wear masks while traveling. Very difficult. Any idea when they will start construction of these roads? No.
Lordship,
This will issue a direction, otherwise, so to be registered. I think somebody must take it up.
Yes, my lord has rightly pointed out.
Hmm? It's because if they top it and then it's okay. Road may be bad, but there is some carpeting so that there's no dust with the traffic. Condition is very horrible.
Lordship,
That's one. In the entire road this time, I was earlier very happy about the environment here, except for the dump which you have on the national highway. Except for that area, this time I find that even in the town area, the garbage dump is huge. That Borum Bridge. I don't know how people are tolerating. You've seen that road?
Yes.
Lordship. Itanagar is little better than this side.
Huh?
Naharlagan. Itanagar is little better than Naharlagan.
We
I
are,
don't know.
we are treated as a steps.
For us, this is also Itanagar.
Government stably treats
Treats
the
Itanagar
Nagaland.
permanent bench. So for me, this is also Itanagar.
I'll give a detail note to my.
Huh?
I will give a detail note. I can give a detail note on why people are not taking out these kind of issues. Because
Achha?
things become personal and your life is at stake. That is the reason.
Is it?
Yes.
Okay. I take note of that. We'll drop a suo moto.
That would be grateful, because
No, if that is so, that
even my members are not secure. Every day we are being bullied. Even I am under threat that I brought the person notice. There is a great difficulty that we face. Otherwise, we are equally competent. We are equally ready to do things for the betterment of the state. But due to things becoming personal and life being at stake, we are not doing anything.
okay. I'll take note of it. We'll discuss.
Only God can bless. God can bless us.
We'll see. I'll take a break and come back.
Okay.
Yeah, Lordship.
Yes.
Lordship, this is a second appeal under section 70 of CPC, 100 of CPC. Lordship, basically like in the second appeal, we are challenging the judgment and order dated passed by the learned civil judge senior division Pasigat by order 27 of 2024. A covering order which was passed in favor of me by the impugned judgment and order dated 27/12/24. That which I have annexed my annexure 10 Lordship, page 52.
Your form of second appeal under section 100 is defective. It has only to be admitted on substantial question of law.
Yes, Lordship, at this stage, Lordship, I praise the let the notice be issued. If the respondent come, Lordship, on that ground, then the
Second appeal notice. No,
Yes.
no, you'll have to get it admitted first. Second appeal is not a matter of right.
yes, Lordship.
Where is the substantial question of law? You have not even incorporated substantial question of law in the memo of appeal.
Lordship, I prepared the substantive question
That
of
won't
law.
do. That won't do. You see section 100, CPC, show him section,
Section.
show him the CPC.
May I, Lordship, say, sir?
Yes, section 100, please read.
Yes. Ma'am. Except and otherwise expressly provided in the body of this court or any other post law for time being in force, an appeal lied to the High Court from every degree passed in appeal by a court subordinate to the High Court if the court is satisfied that the case involved a substantial question of law.
That's the end of section.
Yes, but
No, there
second,
is 1, 2, 3.
yes, Lordship.
Please read.
And say again, sir, an appeal shall lie under this section from an appellative degree pass expertise. The third says, in an appeal under this section, the memorandum of appeal shall precisely state the substantial question of law involved in the appeal.
Have you complied with it?
Lordship, I've made a ground. Usually, Lordship.
I don't know.
Hmm.
I can only show you the law.
Yes, Lordship.
I am not here to teach you law.
Yes, Lordship.
Correct.
Lordship, that we in that case, I'll have to file a fresh one. I'll withdraw this petition.
You don't withdraw it, you amend it.
Yes,
Second appeal, you don't withdraw because the limitation will go.
yes, Lordship.
The learned counsel for the petitioner prays for and is permitted to incorporate the substantial question of law by suitably by suitably inserting the substantial question of law in the memorandum of appeal. Most of matter stands adjourned today. How much time?
Maybe Monday, Lordship.
Okay, you can do it by Monday.
Yes, Lordship, I'll do it by Monday.
Okay. List on 27/5/2024.
Deeply obliged.
May I, Your Lordship?
That's wrong.
Your Lordship, I filed a criminal appeal number 1424 under section 374(2) of CRPC. I filed this petition, Your Honor, to dismiss the.
We will admit the appeal.
Yes, Your Lordship, appeal may be admitted, Your Lordship.
Yes. We will call for the LCR. This is suspension application.
Yes, sir.
You consider it after receipt of LCR. Your name?
TN Minto.
TN Mento.
Yes.
Mr. TN Mento, counsel for the petitioner. And Mr.
T Atta.
T.
Atta. Yeah.
Rajat.
Atta, ETE, Your Lordship.
Oh, ET.
Yes.
Learned additional public prosecutor.
Yes,
for the
Your
state.
Lordship.
Next, the This appeal under section 374 within bracket 2 CRPC is directed against the judgment dated 23/4/2024 and sentence dated 30/4/2024 passed by the learned special judge within bracket NDPS bracket close Bombila in special NDPS case number 23 of 2023 arising out of Bombila PS case number 7 of 2023, thereby convicting the appellant for committing offense under section 21 within bracket small b of the NDPS Act and sentencing him to undergo imprisonment for 3 years, 6 months with fine of rupees 50,000 with default stipulation. Next, the appeal is admitted for hearing. Formal notice on the state returnable in 4 weeks. Full stop. Not so common without requiring any any steps to be taken. Next para, that the LCR be called for. List after 4 weeks. And in this interlocutory application say, so this interlocutory application is filed under section 389 CRPC, which the petitioner is the applicant is seeking suspension of sentence. Next para, issue notice. Returnable in 4 weeks, the state shall file their objection to this application within the next returnable date. Next paragraph, the prayer for suspension of sentence shall be considered.
Your Lordship, if so required, Your Lordship, regarding this affidavit here in opposition, regarding affidavit in opposition in suspension of sentence, Your Lordship.
We have given you
Okay.
objection.
Yes, sir.
I say it as an objection, not an affidavit in opposition.
Yes, sir.
It's an objection. We consider on receipt of the trial court record. In the first also, don't say LCR, say TCR, trial court record.
Deeply obliged, sir. Obliged.
Here, Your Lordship, we are yet to receive the extra copies.
City set this aside.
Your Lordship.
He's a casual employee. Can you
Yes.
transfer him? Under which provision of law can you transfer him? Definitely, they are not giving you instructions, but they don't have any.
Yeah, yes, Your Lordship, we are also not receiving any instructions so far. Your Lordship.
Ask him to be brought back. Yes, respondent number 6, what do you have to say?
We have also no instruction.
Yeah, no
Also now
instructions.
ready to go.
Then we bring him back. Casual employee can't be transferred. There's no policy of transfer. The state doesn't have it. none appears on call for the petitioner. However, Mr. Bhai Viram,
Yes, Your Lordship.
Leonard, what is your designation?
Junior Government Advocate. Your Lordship.
Government advocate. And Mr.
T. Tarin.
T. Tarin,
Thank
then counsel for respondent number 6 are present. Next paragraph. At the outset, the learned government advocate, as well as the learned counsel for respondent number 6, have prayed for some time sometime as they have not yet received their instructions. Next one. In view of the nature of dispute raised and grievances raised by the petitioner in this case, the court is inclined to refuse a prayer for adjournment. And has examined the claim of the petitioner on the basis of materials available on record. Next paragraph. In brief, the case of the petitioner is that he was appointed as a work charged staff by an order dated 1/2/2019, and he was assigned the duty of a casual chowkidar at a monthly wage of rupees 7,000 per month. And he was attached to the office of the executive engineer, Alo PWD division. Full stop. In course of service, by an office order bearing number capital SEA oblique capital E dash capital Roman 4 oblique 2022 dash 23 oblique 1027 dash 29 dated 27/9/2023, the superintending engineer, Alo Civil Circle, PWD, had transferred the petitioner, a casual chowkidar, from the office of the superintending engineer, Alo Civil Circle, PWD, to the office of executive engineer, Mechuka, MECHUKHA, PWD division, which is located in Yomi district. Next paragraph. Although there are some allegations against the respondent number 6, but the court is not inclined to refer to the same. On the ground that the respondent number 6 is a member of Legislative Assembly of the state. And being a representative of the people, he has a right to take any particular stand. First of however, it is for the concerned authorities to act independently and not to mortgage their conscience to the political dictates. Next one. There is the respondents cover by not providing appropriate instructions to the learned government advocate. I have not been able to demonstrate that there is any existing policy of the state to transfer casual employees from one district to another when they are drawing a meager salary of rupees, consolidated salary of rupees 7,000 per month. To stop. The impugned transfer order also does not disclose that the petitioner was transferred and was provided with a official accommodation where he can be accommodated. Full stop. In the absence of any policy of the state government to transfer a casual employee from a court does not find the impugned office order dated and number so and so dated 27/9/2023 to be sustainable. Full stop. Resultantly, the consequential office order. The earlier order is at page 14. The present order is at page 15. Number so and so dated 29/9/2023. They were releasing the petitioner from the ALO PWD division in the forenoon of 29/9/2023 is also not sustainable. So accordingly, the court is inclined to set aside and quash the aforesaid two office orders number so and so dated 27/9/2023 and so dated 29/9/2023 issued by the so first is issued by the superintending engineer RO Civil Circle PWD and second 29/9 is by executive engineer RO PWD division AP. The next paragraph. Resultantly, the superintending engineer RO Civil Circle PWD within bracket respondent number 3 shall pass all consequential orders as may be required to restore the posting of the petitioner to his original place of posting at the office of the superintending engineer, RO Civil Circle, PWD. Next paragraph. As the petitioner is unrepresented, the superintending engineer, RO Civil Circle within bracket PWD, the PWD within bracket respondent number P. Shall act on the basis of downloaded copy of this order, which will be furnished to him by the learned government advocate. Accordingly, the learned committee is directed to furnish a downloaded copy of this order to the respondent number 3, so as to enable the said authority to do the needful. Next paragraph. All consequential orders shall be passed by the superintending engineer, Hello Civil Circle, PWD, within the respondent number 3, within a period of 3 weeks from the date of receipt of a downloaded copy of this order. The section stands out to the extent as indicated above.
May Lordship, please.
Yes.
Here, item number 16, 17, 18, and 19. They are the same analogous case.
Okay.
Now,
What
the
is
petitioner.
what is the order which was not complied with?
Huh?
What is the order which was not complied with?
Oh. Oh, order is page 27.
Okay. Page
27 to 31.
27. Okay.
27 to 31.
Yes, is not restored.
It's already lawsuit. It's already revoked.
Huh?
Already suspension has been already revoked.
Revoked. Where is that? Mr. Patil would not be here.
Suspension. No, they
If
have
you
not.
revoke, he would not be here.
No, no. They have filed the affidavit. I have gone through the orders. They have not complied the court order. Contention is that we were suspended from 29/10/2022, and order was passed. Court passed the order on 9/11/2023. Now they revoke and they going to extend me in the post from 9/11/2023. Then where will otherwise there was no suspension on 9/11/2023. My suspension was on 29/10/2023.
You can merely claim dias non. You can merely claim dias non.
No, they have not declared it.
No, you can ask for it.
Yes.
Because you see, if they don't give any consequential order, dias non is inherent. The principle of dias non, it can't be denied. You'll be, you see, after, what is a suspension after all? A suspension is you are in service. If you are in the suspension, you are still in service. It is only after termination that dias non comes in. We give that period of the period where you are not in service. It will be treated as a dias non so that you are continued in service. That will never happen for you. It's just a date, whether it is 1 or 2, doesn't matter. In a suspension, the restoration of position on 1st of January or 2nd of January doesn't matter. For the period you are under suspension, you will still get subsistence allowance. You will be treated.
The question of subsistence allowance, as per the order, judgment.
There may be some delay, but it has happened. Once you are in service, there's few things you'll have to tolerate.
The suspension order was set aside in court. When the suspension order was set aside in court on 9/11/2023, in that case, the suspension order is no more exists. Now, they try to classify it from the date of order and date of suspension. Unless there is a suspension, I'll not come to the court. So they have not complied the court order. Court never say that their suspension should be revoked from the date of court order, and they should be reinstated from the date of court order.
Yes, Mr. Kapil, what is this review? We are referred to in page 16 of your affidavit.
Lordship, that review, Lordship, we are supposed to file review petition, Lordship. And we have not yet filed the review petition. Since in the meantime, Lordship, this revocation has been already done, Lordship.
Now, since
Anyway, what if Lordship see the judgment, Lordship, directions given by this honorable court, Lordship? Kindly come to page 21, Lordship, of the contempt petition, Lordship. What direction has been given by this honorable court, Lordship? The paragraph 13, Lordship. In view of the foregoing discussions, reasons, and decisions, the present writ petition stands allowed by setting aside the impugned order of suspension dated 29/10/2022, and the response are directed to reinstate the petitioner in service forthwith, Lordship. Forthwith, Lordship, what I understood is, Lordship, from the
4 months, 5 months, 6 months is forthwith.
no, coming to that, Lordship. Here, Lordship, since the original, Lordship, the initial suspension order has been, Lordship, that has been set aside, Lordship. The authority was under confusion, Lordship, from where, Lordship, because forthwith means immediately after the judgment. What I understood is that the authority had a, Lordship, confusion, Lordship. This the service has to be reinstated from the.
No, there is no confusion.
Lordship.
You are stepping in to create that confusion. Because if there was a confusion, they would have written to you. That as a government advocate, a senior government advocate, please explain it to us. What would be the forthwith meaning? Therefore, they are not writing it to the lawyers. That means they are aware what is the meaning of forthwith. You see, please tell us the distinction of setting aside an order of whatever order. There's an order X. That order is set aside. What is the meaning of that? Mr. Patin was trying to raise that issue. Now this order X is quashed. What happens? What is the legal effect? Quashment goes to the date of the order.
Lost.
If an order of supposing there is an order of 1st of January 2024 and I quash it, what would be the meaning? That the order, quashment order goes back to 1st of January. You can't say that the order was quashed on 22nd of May. Therefore, the quashment will be effective from 22nd of May. Which is only the effect of the order, which will happen on 22nd of May. But the quashment goes to the root of the document. Unless you can convince us otherwise, that the order of quashment, unless made prospective, because we only know that if it is not made prospective, it gives effect to the date. You know it well more than I.
Here, Lordship, the direction has been given, Lordship, though that is been set aside, Lordship, to reinstate forthwith, Lordship.
Reinstatement is forthwith. I can't tell someone that please restore him to his position on 1st of January. In 1st of January, supposing you are a government officer, I asked you to be joined on 1st of January. Can you join on 1st of January? Can you sit on your table on 1st of January, 2nd of January? Can you sign on the in the attendance register on 1st of January or 2nd of January? You can't.
No.
Therefore, when I am passing an order, I am doing it consciously. I am saying that order is quashed. He is reinstated forthwith. Forthwith means from today.
Yes. So accordingly, Lordship, the present order, revocation order, from the very date of judgment, Lordship, with effect from date of judgment, Lordship, we have revoked the service of the petition.
The suspension will go back from that day.
A suspension was something in yet with
no, because you see, you'll have to pass a decision, whatever you take, but you'll have to take a decision because you see, after suspension is set aside. His salary was rupees 100. Let us say his salary was rupees 100. During subsistence period, he gets 50%. So he gets 50 rupees for the suspension period. Now on this reinstatement, what would happen? You have to pay 50 rupees for that period he was under suspension because that suspension order is not there. You get the full benefit. Whether you give a date or you don't give a date hardly matters for me. You just have a pleasure of having it after 4 months. But his question is of the suspension order. It goes back to the root. You have to give proper advice.
Lordship. Here, Lordship, that the opinion was taken from the law department. Lord. The law department opined that, Lordship, since initial suspension order itself has been set aside, therefore the this reinstatement should have been done from the date of.
Whatever be, but you have to give.
Then again, the Lordship.
So whereas the court is concerned, we don't find any difficulty because he doesn't lose anything. Whatever date you choose to give, it's just a pleasure you are getting, your officer is getting on giving it from an effect of another date. Doesn't matter either to Mr. Patel or to us. You can't withhold a single rupee of Mr. Patel's client.
So they correct, Lordship. So I'm just apprising the situation under what circumstances.
It's just a issue with ego. Ego was hurt. And therefore Mr. Patel is here. Somebody's ego was hurt. That's the only thing which happened. It doesn't matter to you. You close it and the authorities will take appropriate action. You file a representation to give that effect. Heard. Mr. M. Patel, Learned Senior Counsel, assisted by Mr. K. Dabi, Learned Counsel for the petitioner. This court. Sorry, and Mr. Tapin was senior counsel. No, you are
not as a senior
not as senior
not
government,
as
as a counsel for the respondents. Next paragraph. This court, by judgment and order dated 9/11/2023, passed in WPC 391 of 2023, had set aside the suspension order dated 29/10/2022 issued against the petitioner by further directing that the petitioner be reinstated in service forthwith. Full stop. As the said order of this court was allegedly not complied with and violated, the petitioner has filed this contempt petition on 19/3/2024, and this court by order dated 20/3/2024 issued a notice on respondent numbers 2 to 4. Full stop. By the next paragraph, by filing an affidavit in opposition, the respondent numbers 2, 3, and 4 has projected that by an order bearing number page 16 of the last page of the affidavit. So and so dated 24/2024, comma, in excess of power under clause within bracket C of subject 5 of rule 10 of the CCS within bracket CC and A bracket close rules, 1965, the order of suspension was revoked and the petitioner was reinstated in service with effect from the date of the order of this court, i.e. 9/11/2023. Next paragraph. In this regard, the learned senior counsel for the petitioner has submitted that when this court had directed that the reinstatement of the petitioner should be forthwith, comma, the respondent authorities, by issuing the reinstatement order on 22/4/2024, has deliberately and willfully violated the order of this court. Next paragraph. The court finds that the order of revocation, or the order dated 24/2024 of revocation of the suspension and reinstatement of the petitioner was done only after issuance of notice in this contempt petition. Nonetheless, as the reinstatement of the petitioner is made with the effect of the date of order of this court, i.e. 9/11/2023, the court is of the considered opinion that though belatedly, the order of the court has been complied with. Next paragraph, therefore, the court is inclined to close this contempt petition. Next paragraph, the closure of the contempt petition shall not be a bar for the petitioner to submit his representation for any other entitlements to which he is otherwise entitled to. Yes. You did not follow me? We closed this contempt petition and we have made it clear that if you are entitled to any other to any other
Benefits.
benefits, you can send a representation.
That liberty is always there. And similar order may be passed in,
Similar order may be passed on 16, 17, 18, 19.
Okay. Same date?
Same date.
same date. Lord.
Suspend
Only the-
same date, court order, same date, but different
The name of
WPC.
the parties are different.
Okay.
Different WPCs.
Okay.
I'll give her the name, WPC number.
Yes. No, she will know that because she has the item numbers. She can find it out. She will do it. Don't worry. No, case numbers will change and all the same date, same numbers. But they are otherwise competent. They will do it.
You know,
Yes.
well, this is interlocutory application for implement.
Okay.
Well, before I put forward with certain things, the government of India,
The writ petition is filed by whom?
MS Langit.
You are the writ petitioner.
Yes.
In this implementing application, you have a serious objection?
Yes.
Okay. Yes, what is your right to be implemented?
Yeah, well, just I put it 2 minutes. Here, what had happened, the government of India for vibrant village border area development, following the PMGS guideline, have certain infrastructures to be developed. Now there, the other day, the government council was to produce certain documents according to records, but which I will not be touching that. So here what had happened, pursuant to this, there was an NIT, Milord. Tender process was there. We participated in the tender process, Milord.
What is the date of NIT?
NIT, NIT is in the Milord, read petition, Milord.
No, what is the date? Just give me the date of the NIT.
13, Milord.
Hmm?
Then 3rd April. 13/3/2024.
13/3/2024. Okay, yes. Correct.
Now, pursuant to that, Milord, we participated, all the firms participated. Tender was open, and these part was suppressed in the read petition. We were not made as a party because we participated in the tender. And
same tender you participated.
yes, we participated all that. And then this particular aspect was not disclosed in the read petition, number one. Now, number two, Milord.
Just one by one. Ms. Janjan,
Yes.
if that is the position that the applicant participated,
Yes,
and you are seriously objecting to the impeding,
yes,
then we'll reject his application
yes,
outrightly, correct?
yes,
And we'll say that his right
yes,
to have the tender evaluated for him shall
Yes.
continue.
yes. Because Lordship,
No, correct. You said yes.
sorry, I didn't, I lost
Okay.
track, sorry.
No, it's okay. You see, I have got no grievance.
Yes,
You are objecting to it. I am dismissing his application.
yes,
But with the rider, that the authorities shall continue to evaluate his tender and do what you call to bring it to a close. So far as those, so far as the petitioner is concerned.
no, Lordship, sorry,
Right.
Lordship.
No, you see, you can't have a relief without implementing someone. In your writ petition, if he is not a party,
Yes.
why should he suffer?
Lordship, the issue in the writ
No, I'm
petition.
not on the issue.
Lordship,
I'm on the question.
Lordship, the question whether or not he has a right to be implemented has to be seen
No,
from
we are
the,
rejecting it.
Lordship,
Who is now asking for impediment? We are
Lordship,
rejecting his application,
yes.
but it has to be with the rider that he will not be affected by that.
Lordship, it is not true that on the date of, on the date when the interim orders were passed, the tenders were open, Lordship. In some of the cases, tenders were open, in some of the cases, it was not open. And we are not, Lordship, I'm one,
We are not on that.
Lordship, I'm going again and again towards the issue, but the issue in the writ petition is not tender, Lordship. Issue in the writ petition is for the project, the land of our land, we are not concerned with the tender, Lordship. Our land, which is in which the projects are to be done, for those, the government has to take a consent at least. There is no specific provision for land acquisition, but the government can take a consent from us for the land. Without taking consent, as per the rules, as per the guidelines, they have issued this tender. That is the only thing, Lordship. We are otherwise not concerned with the, we are saying, at least take a consent from us. That is the issue, Lordship.
Milord, if that is the simple issue, Milord.
We are not interested in the tender, Lordship. Once the work starts, then everything will be gone, Lordship.
any participation until Arbitration. There are three proposals.
Where is the tender notice?
My lord, at page 24 of my IA,
24.
24. In the paragraph I have mentioned, page 24, yet, no? There's annexure 1 series, my lord.
Just page 24.
My lord, sorry, 24 that I have made a mention. Yes, my lord, I have just. Second, ये गलत पेजिंग हो गया.
Yes, Ms. Ranjan, where is your tender?
Lordship,
Which page is the tender?
tender, Lordship,
Read निकल ये गलत हो गई.
page 54, Lordship,
54.
54 to 58.
Petition.
54.
Yes. In the Lordship,
Yeah,
in the writ
52.
petition, Lordship,
52, my lord.
Petition.
In the-
52. Read petition, it is 52 or words.
54 is something is middle of a document.
NIT, my lord.
54 is middle of a document.
I mean, read petition.
Read petition, my lord, 52.
Yes, writ petition 178, I have opened it up. Okay.
52.
52, my lord.
Huh?
Corrigan, no, my lord.
oh, sorry, Lordship, it starts at page 49.
49.
49.
Type copy is at 15, my lord.
This is 54 is the sanction letter, Lordship.
No, that's okay. 49 is also something is I don't know, it's not matching. Let's check this.
पढ़ा नहीं है.
I only hope I am not growing old.
Sorry, this is Lordship, this is not the one.
Then
That's item number 20,
171, my lord.
171. They filed the IA in 171 only, not in the.
नहीं है, दिया नहीं. नहीं, सिंगल पेज. ये वाला.
who is for this RWD? Who is appearing?
He's appearing.
Oh, Mr. Stark.
Yes.
Do you have instructions as to this road, whether any private land or community land is being used for road or it's a government land?
Alleged that we have not conduct transit work and we have another allegation is that there was no any land donation. We have report, we are filing our affidavit in opposition to the itself, so we are coming with affidavit.
Coming with an affidavit.
Yes, there is ample document that some of the lands are community land, some person who is affected, they have donated the lands and then there was a transit work. Procedure was followed.
You take it up on Monday. You file it by today.
Monday I had some difficulties there.
Huh?
Monday I had some difficulties.
So you said you are filing it today.
Well,
Lordship,
I have
even if,
60,
Lordship, sorry, may I submit? Even if they do file affidavit,
what they say that transit work has done, or some people have given consent or no consented. I don't know who are the persons whom they allege have given consent. So I will probably need some time, Lordship. So 1 week time may be given. If he files today, then after a week, it may be, Lordship, fixed for disposal, Lordship. In that meantime, I'll need to take instructions also, Lordship.
Milord, this matter, Milord, although I am not yet implemented, Milord, if Milord peruse this letter, is enough to dispose of the matter right now, Milord. 100 kilometer area distance, Milord, no consent is required, because this is a border area project, Milord. Even forest clearance is not required, Milord. But in this case, my client have instructed that we have forest clearance as well, Milord. And due consent was taken. And then, Milord, the petitioner number 1 has withdrawn from the withdrawn as a petitioner in this writ petition. The petitioner number 1 and 64, by filing IA, they have withdrawn their name from as a petitioner. But still, I cannot proceed with the merit of the case or whatever it is, since I am not implemented, Milord.
But Mr. Tara,
well,
she has raised a pertinent question. You see, the challenge of the tender is an incidental challenge. The primary challenge is that the land is theirs, and therefore the prayer B is perhaps the main prayer.
Yes.
Correct. So if it is a question of their land, then perhaps you will not have a right to make any submissions.
Correct.
Correct. So at best, your position in this writ petition
would be only one part, Milord.
Only one part.
Tender part.
So we permit you to be implemented as an intervener.
Intervener, yes.
Lordship, I also have another objection, not only this, Lordship. The person who have signed the affidavit or in the IA, Lordship, he says he's been authorized, Lordship.
Kindly see, Milord.
There is no proper authorization, Lordship.
Originally
Your
there.
Lordship may see at page 36. See the authorization letter. Another thing is, Lordship, it has been filed.
Milord, there's original authorization for all the firms. Normally is
Page 36,
attached with the
Lordship.
wakalatnama, Milord. This is the procedure and practice in our code.
Lordship may see the authorization letter, Lordship, page 36
No, before that, Lordship will kindly peruse.
of the IA, Lordship,
Let us say that. Yes,
page 36
36.
of the IA, Lordship.
Yes.
I, Sri Muri Rajan, do hereby authorize Sri Nangram Pentum. Nangram Pentum is the person who has sworn the affidavit of Sinki Park District to receive and submit tender documents, attend to in technical and financial bidding, and also do any legal activities on behalf of the firm of work name against this till end of the project, as well as sign in any documents legal relating to the above mentioned tender. This authorization letter nowhere says that he can file an affidavit, he can sign an affidavit here. The same thing, Lordship, is in other applicants also. And also, Lordship, in terms of order 30 CPC, Lordship, it is the person, Lordship.
30 will not apply.
Lordship.
Peno Enterprise judgment order by Lordship is there.
Where is the CPC?
कहाँ में निकालो तुम बोलते रहे निकल
I have, Lordship.
Huh.
I have.
Yes. See,
लॉकम भी फाइल किया
तो लॉकम उसको ऑथराइजेशन तो कर सकते हैं।
Order 30 Rule 1, Lordship.
इसका ऑथराइजेशन का है उधर ही
Suing of
हाँ,
partners in name of firm. Any two or more persons claiming to be
यहाँ में petition
liable as partners or carrying on
No, no,
business may
before that
sue
you were reading page 36.
Lordship.
Come to page 36, which we are reading.
36 of
Of what you are reading, authorization letter.
Lordship.
Read that letter again.
Lordship.
Read that, start.
I, Sri Nguri Rajan, son of late Nguri Tanjang, proprietor of MS Goodwill.
Proprietor.
Yes,
So order 30 is not for proprietor.
Lordship.
Order 30 CPC is not for proprietor.
Lordship.
It is for persons who are carrying out business as partners in the name of a firm.
Lordship, I have, Lordship, Supreme Court decisions wherein it is said that a partnership firm and a proprietorship firm are different, and a proprietorship firm is not a legal entity. Therefore, if a person files a case, the proprietor and the person are the same. They are not, the firm does not have a separate legal identity. So therefore, if a person files a case, he cannot file the case in the name of the proprietorship firm. He has to file it in his name, Lordship.
You see,
Yes,
Ranjan,
yes,
and I'll share something with you.
yes.
You see, when we become too technical, you will be the first person who will be hurt. Correct?
Lordship.
There are not one, but there are two constitution bench decisions
Yes,
which says that a firm cannot sue.
yes,
Correct?
yes,
Because the firm does not have a fundamental right. Correct?
yes.
Now, the issue with regard to maintainability will be decided when? What will be the stage of the decision? And if somebody is suing in the name of the firm,
Yes.
you show that Supreme Court judgment. Let us see that judgment first.
Lordship, 1998, I have given the list of books. 5 Supreme SCC 567.
Is it State Bank of India case?
Lordship,
Is it State Bank of India case?
Ashok Transport Agency. Para 6, Lordship.
1998, huh?
Yes.
Yes, which para?
6, Lordship.
What I think is not working.
There is something.
Same. क्या नाम से फाइल किया था? MS Goodwill, ना?
There are other Delhi High Court judgments also on this, but I'm not placing that.
No. I'll show you something more. You
Yes.
have the CPC with you.
I'm aware, Lordship, under Order 30 Rule 4,
No. Come to order 30 to 10.
Lordship. Yes, they can be sued. The proprietor can be sued in terms of.
He's becoming a respondent in your case.
Yes, but in this case, he's the applicant, Lordship. He's not yet a respondent. I can make him a respondent, that's a different thing. But now he's the owner of the suit, so to say.
Because his interest is in the tender.
Yes,
Where
but
is-
can he file
where is-
that,
where
Lordship?
is-
There is the
where
question,
where
Lordship.
is participating, you know.
Can he be a petitioner here, Lordship?
Yes, he's not suing.
Lordship.
He's impleading himself as a
He's
respondent.
he's
He's impleading himself as a respondent.
Lordship. Also, Lordship, I would like to place reliance on 2000, not on this issue, Lordship, on the issue whether or not, in the circumstances, as I have stated earlier, that when the question is the issue, in such a case, whether he is a necessary party, Lordship. This is Lordship 2010, Volume 7.
Please.
417. In this case, Lordship, what happened is the airport authorities had given,
Ms. Ranjan, whatever you show.
yes, Lordship may be aware of it, and
No, it's not question of being aware. I'm not aware of it.
yes,
I'm not aware of the law. That's why I'm here to learn
Yes,
from you. It was presumed that I don't know the law. But you see, in one aspect, I'm very clear.
yes,
Number one, that there cannot be an order, there cannot be any order where interest of a third party is involved.
yes,
And that leads to a nullity in the order. Therefore, the first statement which the court made was, we are dismissing his application. But we are making it clear that there should no adverse orders against the petitioner, against the applicant here. Now you see, you are asking for a stay of a tender process. He says that I have an interest in that tender. Now, can you deny him that interest when your prayer number 1?
no, Lordship, no, Lordship. If our land is taken, and if the
Question of land is something else.
his interest in the tender or no interest in the tender, his right or whatever it is, will come only after the tender process is said to be legal, Lordship, which in this case would be if our land is taken by consent, Lordship. In any case, Lordship, I'm aware of your Lordship's anxiety.
It's not anxiety. I'm not a party to it.
Lordship,
I have
no,
anxiety at all.
I'm aware of your Lordship interest that
It's a no interest. I don't have an interest.
that
You are falsely accusing the court of having an interest.
Lordship, that tender process should not be stalled, that
No,
I'm aware, Lordship,
I am not on that.
Lordship. So in any case,
Please-
Lordship,
you
since,
Please make a statement at the bar
yes,
that whether or not by staying of the tender,
yes,
his individual right is affected.
his individual right will come later, Lordship. It is only after our lands are taken, Lordship, by proper process. In any case, Lordship, since they are filing affidavits today, if the case is listed after a week, then I can also take instructions and the case matter can be disposed of. It's only a matter of a week,
Interlocutory applications are interlocutory applications. I
Lordship.
can't postpone the hearing.
No, no, I'm not asking your Lordship to postpone the hearing. I'm talking about the main petition, Lordship, so that everybody's interest will be served, Lordship. I'm not asking, Lordship. Your Lordship may reject, your Lordship may pass any orders. That is up to your Lordship. But the second part, that whether that the tender process will not be stalled, that part, Lordship, that order may not be passed.
No, that we are not passing. But
Yes.
you're just including them. You see, there are two ways to do it. Number one, he can be an intervener.
Yes,
So that when he's an intervener, his right is limited to his interest only.
yes,
My
He
interest.
can't, as an intervener,
yes,
even I have authored a judgment where we have said that intervener does not have a right to participate in the writ proceeding. He will not be able to file a affidavit in opposition and agitate his objections.
yes,
The only interest is so that the matter can be heard in his presence.
yes,
Number one, that is intervener. And number two is being a party. In a party, yes, for the purpose of one prayer, that is prayer number B, he can't have an objection. When it is your land, he can't object to it because he has got no legal standard to object to your claim to the land. But insofar as the support to the tender is concerned, why he will abandon that claim so far as the tender process is concerned? His livelihood is dependent on that.
yes.
Therefore, if he does not get a tender for whatever reasons, he will be affected. It's a legal question. It's not a question of interest of the court. It's your,
Because the work has been stalled by the
Yeah,
order of this
that
court.
is different. You can't work on, because supposing today,
Correct.
the tender is held, that you'll have to build the road on top of the High Court building. Correct?
Right.
Definitely, the
No.
owner of the management of the High Court establishment will come forth and state. So your right is limited only to the tender, not to the land.
Not to the land. Even I will have no quarrel with them on the land. Because the PMGSY guideline does not provide any land compensation, my lord. Somehow, somewhere, this point has to be determined.
No, it is
It
not
will be-
true. It is not true that does not provide. It only says the state government may make arrangements. State government can either take consent by way of negotiation or they can compensate for the land. It is not that there is no sort of any compensation. That is the position here. Because maybe the money is limited, so this kind of arrangements are made. There is a different thing, of course, but the consent has to be there.
That I'm filing affidavit, my lord, on Tuesday.
Land has been donated by.
What I'm suggesting is, Lordship, I'm also, I'm anxious that the case be disposed of quickly. So therefore, if he files affidavit, let the matter be listed after a week. I will take instructions if there is to be taken any.
No, this IA has to be disposed of. The main
Yes,
petition
the
we have
Lordship may
entered.
pass any order in the eye that I've.
Lordship, I agree to the both proposals, either as an intervener or
Okay, let
as.
it be on Monday. You had it by, you are having it on Monday.
Today we are, I'm.
So we are taking it on Monday. You have time Monday, today and Friday to file it. If you can't file it.
Monday, my lord, I have something, I will
No,
be out of this.
Tuesday, my lord.
Tuesday.
Tuesday. I'm also coming back on Monday.
My lord, may I suggest, my lord, like I said earlier, even if they do file, I may need to take instructions, Lordship, because it may be a very voluminous thing, Lordship. It is not a question of one person, Lordship. It is 93 persons, Lordship.
Delaying,
So therefore, Lordship,
Your office is under,
26 works are there.
your office is
There are
perhaps under
26
surveillance.
project in,
Your office is under surveillance. They also know that you are filing a voluminous.
no, it will be, since it is a case of not only one person, I can, I can assume that, Lordship. So that is why, Lordship, I say,
Agree to a date of
Lordship.
Consult and have a date.
because like my friend is so worried because the entire application, the
Nahin.
petition has been filed, lead by one person only. So. And my lord, kindly see that locum enterprise, petitioner number 2 has duly authorized me, that is with the Wakalat Nama. Original that we.
He's on a different footing, you are on a different footing.
Yes.
He says that once you are a firm, the firm does not have a right to come to court. He is hitting you there. But the fact is that if you take a very strict view in one case,
Yes,
it will be the bar of 4 states to.
Lordship, I was suggesting 3, but my learned friend says 5 of June. Next week.
Yes. Why? You file on Tuesday. Today you are filing.
I'm
Let-
filing, I'm
He will be filing today, but I'll also, and give me a chance.
No, we will give you a chance. Well, let it be listed on Tuesday.
No,
He
that
is
will be-
filing
not be
today.
there.
And
He should not be there.
no, but he is filing today. My brother.
No, even
Tarak-
if he is there,
My brother
we may not
Tarak
be in
is
a
filing-
position to argue.
No.
Because I may need to take instructions, Lordship.
No, you may take instruction, my lord. Let it be listed on Tuesday, my lord. He is filing the
Three
affidavit
of us
today.
can't interact. Just a
Yes.
moment. You see, he's not filing an objection in their implementing application.
Yes, Lordship.
It is between him and you.
Yes.
Why should that be postponed?
No, it's not with him, Lordship. I'm talking about the writ petition, Lordship.
Writ petition, we are not fixing a date. I am on this application. I am first
Oh,
taking up
this
this-
application, Lordship, may dispose of anything. I have no, I have made whatever submission I had to make. It's up to, I leave it to your Lordship.
So that Tuesday on this interlocutory application, this affidavit. will be
This
taken up-
affidavit, we are talking about the main case. Because
This petition, it goes to whatever. date you agree.
I am not.
5th and 6th, whatever you agree.
I have not.
When do you-
Well, I agreeable to
5th.
both the issues,
It's okay, we'll take
either
it up.
as a
Let him
intervener or
file an
either as
affidavit.
a
Let him file an affidavit.
party.
So this is interlocutory application. Mr. T.T. Tara, counsel for the applicant. Ms. and the counsel for the writ petitioner. And Mr. G. Tarak Leonard, standing counsel for the RWD. You're also there? Mrs. Vairi Ram, Leonard committed to it for respondent number 1 in the writ petition. Next paragraph. List this interrogatory application for consideration on Tuesdays 28/5/2024. In the writ petition, you say here petitioner would be Mr. Angel and Mr. Tarak and Mr. Marina. The learned standing person for the RWD submits that he would be filing an affidavit in opposition within
Today.
In, I think 21, 22, not in a year.
no, item 21/20 when?
Today is filing.
We are filing today.
Okay, we're filing.
Filing time is already over.
In
Time
course of the
over
day
till
today.
tomorrow.
Uh,
Tomorrow no.
Day
Friday.
after.
Friday.
Just make it day after tomorrow. Till by so and so. By 24th. 24 by 20. Stop. Is the learned counsel for the petitioner prays for some time to obtain instructions thereon and take appropriate steps. First off, accordingly, the corrected this repetition shall be listed on 5/6/2024.
Along with this. Well, if it is listed on next Tuesday, then my learned friend Nikita can have the copy and then we will allow
We don't
them
know
to
what she
file
does.
1 week. Yes,
I
Milord.
don't know what she does.
Yes.
Lordship, in the writ petition, the interim order may be
Wait,
continued.
Lord, interim order extended.
Okay. Speak for this. Very good.
Your
Yes,
second
yes.
time returning back. Give this back.
Lordship, sorry, the order has been passed, but in the interlocutory application, since we have already made submissions,
No, we are postponing it still. You see, you have used few words where we will not like to take it up now. You will be under impression that I have an interest, I have a,
no, it's not like that.
so,
It cannot be like that.
so once you say that, we are postponing it.
Correct, correct, correct.
When I am taking up the bench, irrespective of the stage of motions, admission, orders, I am taking up hearing and advice stage. Correct. So,
My Lordship,
yes,
I'm appearing on behalf of Jumgam Jini, amicus curiae in this case. He informed me that he reached this morning from the Guwahati, so he could not go through the case record today. So he is asking for the adjournment. Matter may be fixed on Monday, Lordship. Next week.
In that case, matter may be fixed on 29th of this, 29th. Wednesday. 29th of May, my lord.
both sides are represented on the prayer made by learned counsel for the respondent, matter stands adjourned today, list on 29/5/2024.
Obliged.
Deeply obliged.
We'll have time today.
My lord, criminal, jail appealment.
This is jail appeal, yes, I
Jail
understand.
Under 376 IPC. Under 376.
So that's the time they constrained. Just a moment. It's not a case of, it's a case of acquittal.
The case of only, conviction of only. So
It's not supported by medical evidence.
Yes, yes.
It's there, it can be without, even without having any possible intercourse or any physical injury, it can be done. But there is a ruling also. When slight achieved, that almost
Offender.
comes under the definition of.
The girl doesn't say that she has only been touched and he left away. It doesn't say that. The girl alleges that she has been raped.
Yes, it may not be complete penetration, but it may some slight penetration. I mean, it amounts to rape.
No.
There
If
is
the, you
allegation
see,
of
if the
penetration.
girl in the evidence would have said so, we would have agreed with you. But where is the statement of the girl? The girl doesn't say that slight penetration and he left. You see,
She didn't say any complete penetration of them. She only said she was raped. And for medical evidence also, when there is a slight penetration, there cannot be have any bearing of bearing this physical injury or whatsoever. That's a discuss me then discussion. Even without structuring highway, this can be done. This cannot, medical.
My lord, to be taken up on Monday, my lord.
Monday we have a lot of cases otherwise fixed. Make it Wednesday. Wednesday. It is possible, Administrative Sound Council for the legal aid counsel for the appellant and Mr.
G. Tado.
Tado Leonard, APP appearing for the state. Due to positive time matter could not be taken up today. List on Wednesday is
29.
5/2024.
Obliged one.
May it please your lordship. Lordship, this is appeal against the conviction. Appellants.
It has to be adjourned. We have to take up some other day. Don't have time to take up. Huh? Your name?
Jayaloji.
Counsel for the appellant, Ms. G. Jenny Leonard, ABP for the state. The positive time matter cannot be taken up today. List on. Hmm? What is this one? It's 28. Make it Thursday. 9:30, 30. List on 30/2024. What is the medical evidence here?
Page number 10, Your Lordship.
And who is what is the name of the deceased?
Jagdish
Jagdish Panda.
Pandav.
There's strong evidence against you. There's strong evidence against the appellants.
Yes.
Thursday.